Can I just say something about Andrea?
Hey guys, welcome to my my tiny little New York hotel room. Oh, I've been here in New York City since Sunday. I got in, and I have been here for the Luigi Mangione motion to suppress hearing. I got real interested in this hearing because it's, from a legal standpoint, pretty much it's extremely significant, potentially dispositive in the case for a number of reasons. So what is going on with this particular motion is that the defense is moving to suppress both statements that were made at the time of Luigi's arrest, arguing that he wasn't Mirandized when he was required to be Mirandized, and then that he was also unlawfully searched. At the time that he was arrested, police began to go through his backpack. They did not have a warrant at the time, and discovered in this initial search at the McDonald's, they found a firearm magazine in the backpack. At that point, according to the motions and the reports, they seized the backpack, took it down to the station, and then did a more thorough search, also without a warrant, and this time discovered a variety of other things, a firearm, notebook that contains writings, and so forth. So the reason why this is so significant is because at the time that Luigi was arrested in Pennsylvania, he was arrested for violations of Pennsylvania law. He gave police officers the New Jersey identification with the name Mark Rosario. This was the same identification that was associated with the shooter who had checked into the hostel in New York. So that's, not great facts, but in and of itself, probably not sufficient to arrest him on the New York murder charge. So he was arrested for forgery under Pennsylvania law. And, subsequently, then these searches are what produced the bulk of the evidence that was there to link Luigi with the shooting. And although we haven't seen the search warrants and the other grounds, the arrest warrant and so forth from New York, both the federal and the state cases, highly likely that those relied on the evidence that was found in the backpack in order to show probable cause to believe he was the New York shooter. So that's kind of a long way to get around to saying why this motion is so significant, because if these searches are invalid, then everything they found in the backpack is fruit of the poisonous tree, and anything that relied on that evidence is potentially tainted and can't be used to prosecute him. So basically, if the defense wins this motion, it's going to be very difficult, if not impossible, for the prosecution to go forward. On the other hand, if the defense doesn't win this motion, then the evidence that has since accumulated from the time of his arrest is pretty incriminating. It's pretty inculpatory. They've got the writings in the notebook that describe the planning process, the purpose behind it, how the target, Mr. Thompson, was selected, the motivations behind that. They have the firearm. Done ballistics testings, which they claim, are going to match the firearm to the bullets that were used at the scene, the shell casings that were recovered at the scene. Of course, if you've been with this channel before, you know that actually matching the firearm is a bunch of bullshit. They can't actually do that, but they can, at a minimum, say that it's going to be consistent with that. They have a bunch of video. From the video, they watch the shooter's movements. The shooter left some items around, some trash, a cell phone, things like that. They've recovered DNA from those items. The DNA matches to Luigi. So that stuff is all pretty bad, and makes for a pretty strong case against him if they don't win this motion and that evidence does remain available for the prosecution to use. So real significant point in the case here. So I wanted to see it because this is one of those issues where the details are really going to matter. in terms of just being able to evaluate, this motion and the ruling, not just, is it the outcome I want, but has the process been done the way it's supposed to be done? Is this being by the book? Are they being fair? Are they treating him the way that that people accused of crimes in this country are entitled to be treated? And is there justification ultimately based on good facts, good law, good process? These are things that are, of course, important to me as an attorney. But getting in to see the hearing is not necessarily the easiest undertaking. So I don't have a press pass here in New York. I think if I try to come back for any other part of the process, I might try to do that, because it's quite clear the press gets completely prioritized in terms of being able to access the courtroom. They get brought in first. They get like a massive number of people there, compared to the members of the public that are allowed to attend. So I wasn't able to get into the courtroom on Monday, but I was able to get in on Tuesday. There were about 24 members of the public that were allowed in on each day. And that amounts to roughly, the seating in the courtroom is like, they have the pew, it's like pew type seating, like church pews, hardwood, bench things. And they sit about eight per pew, and there's 2 pews with, an aisle down the middle. So the public gets 3 of those. The press got like 9. And then there were like some empty ones in between that they never even filled in, but for whatever reason wouldn't allow more members of the public in. So the seating is very limited for the public, and as a result of that, there's competition for the seats. So there's a line, and the line started forming really early, apparently as far back as Friday or Saturday for a Monday hearing. So I got here Sunday night, and I was already, like number 30 in line. Unluckily, I was going to be able to make it in for Monday, but I went ahead and stuck around to see if I could, and did not. But then, that got me towards the front of the line for Tuesday. So yeah, let me tell you, sleeping out in New York is not for the faint of heart. It's cold. It's cold out here right now. It's been like 20 some degrees. I got lucky, missed most of the rain. Sunday night was real miserable. Monday night was a lot better, but it's a city. There's like constant noise. You're constantly getting woken up. Like it's a whole experience. But hey, do what we got to do to be able to get in and get the details. I have been following the a lot of the live tweeting as well too, just because there are a number of reporters who are able to get in, and I just would like to see, are any of these people going to be able to provide, the information and the level of detail that I the lawyer, am going to need to know, what are we working here with, from the standpoint of the facts that the court is going to have to find, and where those are going to lead them, legally speaking. And some are better than others, but by and large, it's just no. I'm not getting what I need to get from these folks, which is a little bit on the disappointing side. But just that is what it is. The media, by and large, is not legally trained, so they're watching it with not necessarily an eye to what is going to ultimately matter in terms of the decision making in the case. I read one series of live tweets that were like, I couldn't believe it. It was things like, yeah, the attorneys are asking questions and the witness is answering them. And I'm like, why the hell are you even here? How on earth is this a useful report? Of course they're asking questions. It's an evidentiary hearing. Like, we need to know what questions are being asked. We need to know what the answers are. So that's all making it a little bit difficult to be able to follow this and get good information and have a good strong perspective on where everything is going. There's been a little other challenges to transparency in this case that I'll talk about in a little bit when we get there. But anyway, so I did miss the hearing on Monday. I wasn't able to get in, but I read the live tweets about it to kind of see what happened. And then I was able to get into the courtroom on Tuesday, spent the day in there. I have my very extensive notes, in fact, 27 pages of them from yesterday. Court's not in session today, by the way. It's going to go back in tomorrow, and I don't know if I'm going to make it back in there or not either. I'm going to probably wander down later this evening and see where things stand, but I'm not real enthusiastic about another night sleeping out on the streets here, but we'll see. So I have my 27 pages of notes. I'm going to go ahead and go through to just bring us up to speed on what happened on Tuesday. Get the details in there, and then where things came up that caught my attention, either because it's going to be significant from a legal standpoint, or just for some other reason, caught my attention. It's worth mentioning. Then I'll go ahead and break in and talk about that. So, yeah, the courtroom itself, I've already kind of described. So there's like 10, maybe 12. There's a ton of bailiffs in there, like a massive amount of security. I can't imagine that that's normal. It's very likely that they've beefed everything up for purposes of this hearing, given the nature of it and so forth. They do have Luigi in civilian clothes. He was wearing a suit and a shirt with no tie. But they bring him in handcuffs and then take the handcuffs off of him while they set him down. So when they first brought him in the morning, they bring in the press cameras. They have some press cameras out in the hall, like snapping pictures of all of us walking into the courtroom, like that's some kind of a story. And then they allowed the press to come into the courtroom and into the well and like stand in front of the bench and just like take pictures of Luigi sitting there at the table. It was this bizarre photo shoot. I didn't really know what to make of that. Not a fan, like definitely not a fan. I had a case once where the press was taking an interest, and my client he was in jail, and so he was being escorted from the jail through the hallway into the courtroom, and so the press is up there in the hallway with their cameras, and I pissed them off because I took my file out and I stuck it in front of my client's face, like, fuck you guys. I mean, come on, this is not a freaking runway show. But they really, it was just this bizarro world, magazine shoot almost kind of thing. And so I have no idea, what they got in terms of pictures. I don't think I've seen any of them yet, but I felt like, what on earth is he supposed to do? Is he supposed to pose like that wouldn't be obvious? Is he supposed to like pretend like he doesn't notice them? I mean, this is one of those situations where there's no winning. He's gonna get photographed. He's gonna get pictured. It's this completely artificial type of environment, and it's gonna get criticized and critiqued and picked apart and so forth. Ooh, look how he looks and and all that type of thing. So yeah, really not a fan of any of that. When the judge came in, it was a little bit surprising. It like caught me off guard because they don't ask you to stand for the court in New York. Apparently, like it's informal. He just like sort of walks in and somebody shouts out like, "Hey, court is starting. Court's in session." Like, oh, normally they say all rise and the judge comes in and then you sit down for the judge. But they don't do that here. So, or at least this judge doesn't do that. So it took me by surprise when court was getting started because I'm kind of used to that script. So they started off the hearing with a stipulation to the authenticity of the Altoona Police Department body cams. Multiple police officers responded to this scene. We saw several pieces of body cam footage, but there is a lot more than they showed us in the court hearing itself, but they did introduce them all as evidence. So there was a stipulation that they were authentic. The defense indicated that was with a caveat about how they were going to be used during the hearing that had been discussed previously. And we learned a little bit more about that as the case went on. And then they also noted that one of the exhibits, number 11, which was the criminal complaint from Pennsylvania, contained Mr. Mangione's home address, and so it was redacted by agreement of the parties. So we had one witness yesterday, okay, one witness that we got through. This hearing is supposed to be 3 days. It was supposed to be Monday, Tuesday, and Thursday. I don't think they were never planning on having court today. Not clear to me if they were planning on spilling over to Friday. But the witness list for this hearing is like 28, I think, 28 witnesses or something like that. They got through maybe 5 on Monday, and they got through 1 yesterday. Like this is not moving quickly at all. So I have a hard time seeing how they're going to get everything done in the time frame that they have allotted. But yeah, we'll see. So what we had was Joseph Detwiler. He was the arresting officer in Altoona, Pennsylvania. So very important witness because, of course, he's the guy that is kind of the face of what the police did. And these are the ones that asked him the questions, decided when to Mirandize him, decided when to look through the backpack and so forth. And so if there are legal issues with that, this guy is going to end up kind of being the face of that. And so he's kind of your, typical bald white guy cop. If you watched Karen Reed and you saw all the thumbs up on the stand, he's kind of another one of those guys. He demeanor wise, he had the fairly typical antagonism to the defense, much more open and kind of trusting with the prosecution. And then as soon as the defense is asking questions, the guard is up and there's some visible hostility. But on direct, he's relatively calm. He's not like a flowery speaker at all. Not super articulate. There were some points where that might be an issue. So I'll talk about that when we get there. He's been a police officer with the Altoona Police Department for 14 and a half years. Before that, he was in the Air Force for 4 years, where he was basically like a security guard. He guarded weapons and aircraft on some base in Italy. After that, he worked as a security contractor in Iraq for 1 year. He was honorably discharged from his military service and then moved on to do the police academy at Harrisburg, Pennsylvania. That was a 4.5-month training where they train in traffic and crimes and, learn all the stuff that they need to learn to be a police officer, learn about search and seizures, when to arrest, when to frisk, what the rules and regulations are, how to question suspects, and so forth. So prosecution is laying a foundation here that they have standards for how to do these things in Pennsylvania. He's familiar with them. He's been trained in them, and ultimately is going to argue that he did things the way that they are supposed to be done in Pennsylvania. He then, after the academy, did their quote-unquote on-the-job training, which is far more extensive. They learn about things like drug activity and domestics, and they get more in-depth into what the crimes code provides, the details of Pennsylvania law and what crimes are. This is where, they learn all their expert stuff, like, what's a street level amount of narcotics and versus a user level versus a dealer level, and when is a tattoo a gang tattoo and stuff like that. This expertise that police often bring to their testimony on the stand. That's where he was learning that kind of thing. So Altoona itself has a population of about 50,000. They have 65 to 70 officers. He described it as a high crime area, which sort of surprised me because it's not urban. It is in central Pennsylvania. The largest close city is Harrisburg, which is about 2 hours away. It's about 2.5 hours from Pittsburgh. It's about 4.5 to 5 hours from New York City. And it's a very, very busy department. So my impression, this is probably like a blue collar area. I would imagine similar to Pittsburgh. I looked up a little bit and it's like an old railroad hub. And so I would imagine it's kind of similar to a lot of this is like the far northern end of the Appalachian Mountains. Kind of similar where it's, former industrial that has, probably not done so well in past decades, and a lot of job loss and things like that. But yeah, described as a high crime area, and so the department is very busy. So he was working in the patrol division. His job was to respond to calls. He was working the day shift Monday to Friday from 8 to 4. And that's the shift that he was working in December of 2024. His supervisor at the time was Sergeant Dustin Thompson, and Lieutenant Hanlon was also on shift. He identified some other folks who were going to have their names come up. Deputy Chief Swope, Sergeant John Burns, who's part of the narcotics division, Sergeant Eric Houston, who is a detective. They do not do foot patrols in Altoona. They just go around in their marked vehicles. It's kind of a modern policing method. Everyone does that now. I don't think even in New York they do foot patrols anymore. They might, like some places in Midtown, I guess, maybe. But by and large, that's what happens. Police have moved into their vehicles, and so it's created a lot of separation between the police and the policed. Because they're behind a wall. You're not walking down the street, chit-chatting with the shopkeepers and so forth. It's just not how policing is done these days. He was in vehicle number 106. It has a computer, a radio, and a license plate reader. The CAD system, which is the computer-aided dispatch, runs on the computer. And the 911 calls are operated by the Blair Dispatch, Blair County, Pennsylvania, where Altoona is located. So on December 9th, 2024, he was in a double unit with Officer Fry, who was a rookie. He's a rookie out there now. Detwiler makes sure to emphasize later on in his testimony, he's not a field training officer. Okay, FTO is a very specific thing in police. It's like a rank you have. You often get additional duty pay if you're training somebody as an FTO. He was not that. Wanted to make sure that was clear. But he's really performing a lot of, very similar function. They're riding together in the same car so that he can, show him how it's done. This is how we do cop things, so that the new guy can benefit from the experience of the guy who's been there a little bit longer. Most patrols are alone, so this was a little bit unusual to have the two of them riding together. He didn't remember what his sector assignment was that particular day, but there are 4 geographic sectors in Altoona that they assign their patrols to. So at 9:14 a.m., a call came in from the Blair 911, and that was played, that call, and the call basically said that there was a customer saying, or no, this was not the call. We heard the dispatch radio that was like reporting the call over the CAD, over the radio system. And they were communicating that a customer says that there was a male in the store who looks like the New York City shooter. Detwiler hears this and says 10-4. And he describes this as being kind of semi-sarcastic because he did not think, he thought this was a bullshit call. He didn't think it was going to be the person that they thought it was. He actually got a text from, I think he said the Lieutenant Hanlon, that said, if you get the New York City shooter, I'll buy you a hoagie. And he texted back, consider it done. So they have these text messages where they're making jokes about, hey, if you get the New York City shooter, haha, isn't that going to be funny? Wonder if they're regretting that in hindsight. So they responded to the 507 East Plank Road, which is where the McDonald's is in, well, there's 2 of them, but that's the McDonald's they were called to in Altoona. He has been there for different calls before. He has eaten there before. The CAD report said that the person they were looking for, the person of interest, was wearing a brown beanie, had a blue medical mask on. And so they arrived. He was equipped with a body-worn camera. He wears that on a daily basis. It's in good working order. He wears it on his chest. You can kind of see. You can't really see it on him, but you can tell from the perspective. It's sitting right about there. You turn it on, and there's a lag with the audio starting, which is fairly common with these systems. The video will start to run, but the audio takes some time. Sometimes it's a few seconds. Theirs, they say, is up to a minute to activate. So the video starts, but you don't get audio until some time has begun to lapse. He did not run his lights or sirens when he was responding to this call because he didn't think it was going to be the guy. Didn't think this was a serious call at all. Just kind of, got there and dealt with it when he had to. Now he tells us he watched a lot of Fox News. This guy watches a lot of Fox News. Officer Detwiler does, and so he had seen a lot of videos and articles on the shooting. He had seen the pictures that had been released of the person of interest many times over the last 5 days. And he was asked if he could put a number estimate on that. He did not. He just said a lot. So he was shown an exhibit that was introduced on Monday, Exhibit 1, which is like just a big collection of the photos that had been released over those early days in the investigation. And he identified which ones he had seen before on Fox News and which ones he hadn't. Most of them he had seen before. So like there's the pictures from the hostel. He had seen all of those. The picture of the guy on the bike and then the one from the scene with the guy holding the gun. He had seen those on Fox News. The ones at the hostel without the mask, with the mask taken down, he had seen those. The photos from the cab, the taxi cab, a couple of those were released. He remembered seeing one of those, the one where he's looking like through the slot in the inside the cab. There's a second one where he's outside the cab, and it's kind of like a profile view. He did not remember seeing that one. And then we saw the video of the shooting. There's two of them. There was a kind of truncated one that stops right before the shooting is happening, where you see Mr. Thompson walking down the sidewalk, and you see the man come out from the left side of the screen, kind of come behind him, lift the gun, and the video cuts off there. He indicated he had seen the entire video, not this particular truncated one. But then the photos of the guy he had seen. He had read about a search of the pond in Central Park. They sent divers down into the pond to look for a firearm. He hadn't seen, there was like video of this search that was being played on Fox News. He did not recall seeing the video, but he did recall reading about the search, and that as far as he knew, the search had not been successful. They were still looking for the firearm because they hadn't recovered it. He didn't remember where he read that. Then we watched the full shooting. So the full video. Looks like it's a different camera, slightly different angle. But it's kind of, the camera angle is from above and behind where these events are taking place. It kind of looks like where if there's maybe an awning on the above the sidewalk. This is taking place out in front of the hotel. It looks like maybe the camera is from like one side of the awning. So yeah, same thing you see, except then you see, fires the gun, and Brian Thompson kind of stumbles off to the side and falls, and the shooter like approaches him. Yeah, it's not real pleasant. Not the most graphic thing we've ever seen, but at the same time, watching somebody be killed is not particularly enjoyable. So he had seen the video, but he couldn't remember where. He thought somebody had sent it to him, and that later on he went to try to look at it again, and it had been taken down. So it sounds like, you know, somebody had posted it somewhere, and then it vanished. So he had seen it before the call on December the 9th, and he, you know, was interested in the case and kind of paying attention to it because of the nature of the crime. He thought it was awful, and he was disturbed by what had happened. Pages are sticking together. He thought that it appeared like the shooter had been lying in wait, and that's part of, you know, what had bothered him about it. The prosecutor asked him if he had an impression whether the crime was premeditated or spontaneous. This was objected to, and that objection was quite properly sustained. This is just pure opinion stuff. That's not in his pay grade to make those calls. That's for the fact finder to decide. He saw that it involved a black semi-automatic firearm, appeared to have a silencer at the end, but he did not know what the motive was, had, you know, no clue about any of that. So the defense at this point renews an objection to the photos that had been introduced that he did not recognize. That was overruled. So he again remembered that the firearm had not been recovered in media reports. The Altoona Police Department was not working with the NYPD, so this wasn't, you know, this wasn't like a joint investigation or anything like that. It was just something he was paying attention to on his own personal time. On their morning roll call, another kind of typical law enforcement activity, when they have the shift change, they'll do like a big group meeting to kind of, you know, tete-a-tete what's going on, what happened the night before, what's going to be going on today, what the assignments are, and things like that. So before December the 9th, they did not discuss the New York City shooting in roll call. They didn't have any kind of professional discussion about it. He didn't recall there being any casual, like, you know, not part of their job duties discussion about it either, you know, water cooler kind of chat. Didn't remember that coming up at the station. So we started watching Bodycam at this point in time. And so what the prosecution did, it was Detwiler and Fry that were the first two responders to the scene. And so they would kind of jump back and forth between Detwiler's video and Fry's video, because Fry's video would show Detwiler, you know, Detwiler's own video doesn't show him, but Fry's would show him. And so they would kind of, you know, jump back and forth between those to narrate what was going on. So it started at Detwiler's video at 9:27:46 a.m. The call had come into dispatch at 9:14. They don't get the call relayed to them until sometime after that. It was 9:27 when they had been driving to the call. They were kind of just getting to the scene, and that's when they activate the body-worn camera. They didn't turn it on for the drive. He turned it on like once they were getting close. He was driving, Fry was in the passenger seat, and then they had a long sidebar to talk about Fry's body-worn camera. And I know the reason why is because the defense was basically objecting to using body-worn cameras other than Detwiler's, because there are periods of time when he's not in the scene, like they're in different places, he's gone outside, Fry is still inside, stuff like that. So he doesn't have personal knowledge of what is actually shown in those portions of Fry's body cam. They you know, flesh that out a little bit more later on. We didn't get to hear that at sidebar, but it was pretty clear in certainly in hindsight that that's what they were discussing. So they came back and had Detwiler lay some foundation that before he came to court, he had watched all of the body cam footage. And so he saw himself on other, you know, the other body-worn cameras. He looked at Fry's, he looked at McCoy's, he looked at Yeager's, he looked at Fox's, he looked at others. There's a lot of cops there at the scene, and we kind of get to know some of the names a little bit. And that from his review, those cameras accurately represented what had happened based on his own personal knowledge of the events from that day. The defense asked to voir dire the witness as to the admissibility, basically, of these particular documents. And so that's basically a process where, the state has laid a foundation, and you think you might have some additional questions that would either help establish the foundation or undermine the foundation. So she asked basically if there were times when he had walked out of McDonald's. He acknowledged yes, there were 2 times when he did that. That he watched all of the videos, but he did not, he didn't see what had happened when he wasn't there. Of course, you weren't there, you didn't see it. And that was also the case when they were at the station. He wasn't always in the same place as the person whose camera is running, and so he only has personal knowledge of what he saw when he was present. So he can't see himself on his own body worn camera, but he thought that the other videos would help by showing him in the video and what he was doing. So ultimately, this defense objection was overruled. This is going to be a repeated issue. It's going to come up a few times. So I'll discuss that a little bit more when we get to where they're kind of arguing the point a little bit more. So he responded with Fry. They were the first ones on the scene. And we watched the camera. We watched Fry's camera first. So we saw him walking in first. Fry was behind him. McDonald's has 3 entrances. And so he said at least 3. So they went in the main entrance. There's no audio at this point in the camera yet. It's quiet, and the audio comes on as he's turning right to go past the cashier area into this back seating area that's back near the bathrooms. The way this McDonald's is laid out is, I don't know, it's a little odd. There's this, you walk in the front, the cashier is right in front. There's some tables over there, but then there's this hallway, and then it opens up to another room in the back that has more booths, more seating, and then the bathrooms at the far back. Then right kind of before you get to the bathrooms on the right hand side, there is another door, another exit. So they went in the main one. The audio comes on as they're going back through this little hallway towards the seating area. So they go through the hallway and see the man of interest, the suspect, who is sitting in the back left corner, and he's right over kind of next to the bathrooms. He's got a large coat on, a brown beanie, and a blue medical mask. So first, Detwiler walks past him, like towards the bathroom, and then comes back, and he explains that he walked by because he wanted to see what he was doing when he first saw them. He says that the guy was on a laptop computer. Now, this becomes a little bit of a point of controversy because it kind of looks like he's on a laptop, but as things unfold, like it's never, you never really see the laptop. Like where is this laptop? Where is this mystery laptop? I don't know. So entirely possible he was not on a laptop computer at this time. You do not get a good clear view of him being on a laptop at any point. So he approaches, asks the man, "Hey, do you mind taking your mask down?" And he says, "Sure." So he pulls his mask down, and then of course we see that it's Luigi. As for his name, he says Mark Rosario. Detwiler tells him that somebody called and said he was suspicious, and so he asks him if he's got ID. And so Luigi gets into his wallet and pulls out an ID and hands it to him. When he asked him to pull the mask down, Detwiler says, "I knew it was him immediately." He knew it was the shooter as soon as he pulled the mask down. That's what he says. We've all seen the photos from New York, and most of them are masked. So, I don't know how pulling the mask down is going to make you, suddenly certain that this is your guy. But that's his story, and that's what he's going to stick to. So they have the 2. There's actually 3, I think. No, the third one from the hostel, he might have his mask back on. There's, the two from the hostel where the mask is down, one of them where he's smiling, one of them where he's just, kind of looking forward. And they're from that high looking down angle, from a camera. So it doesn't give you a good like face to face perspective on this person either. So again, just some little details that make it a little bit challenging from an identification standpoint. Like, yeah, I'm not really sure about that. And then the whole other part of this, of course, is we've talked so many times about eyewitness testimony and the problems with identification. The problems with eyewitness identification are legion. People don't remember stuff, the way that we think we do. We think it's like a video camera. It's not even remotely like that. It's constantly a process of writing and editing and updating and revising and so forth. And it's extremely influenced by our psychology, by like what we want to see, what we expect to see, and things like that. So there are, all kinds of cases where somebody will, have a rapid identification. I saw this person instantly and I was 100% sure that it was him, and they're completely wrong. Like, absolutely, completely wrong. It happens all the time. So I found that kind of notable. I don't expect they're going to like bring in expert testimony or anything like that for this type of a hearing. It's just that, like, if you've been around criminal justice for really any length of time, like, I made a rapid 100% certain eyewitness identification just like that. It's major red flag, major red flag. So he knew it was him immediately, but he stayed calm and asked the gentleman if he'd been to New York recently. You've been to New York recently? And he says, yeah. So Detwiler gives Fry the ID that Luigi gave him to run it through the NCIC with the dispatch. The NCIC is a National Crime Information Center. This is like the big national database that the Department of Justice operates. And yeah, it's got all the criminal records, all the warrants, all the identification numbers, like everything. Massive database of people in America. So basically, if you've ever gotten a state issued ID, a state issued driver's license, anything like that, you are going to be in the NCIC. So reiterates the license is from New Jersey. It's in the name of Mark Rosario. The NCIC, according to him, will bring back the name, it will bring back the date of birth, it will bring back any kind of warrants. And his objective here was to try to identify who this person was, right? He knows it's the shooter, but now he's trying to identify who it was. So if there's no record that comes back from NCIC, they can't find the name. And according to Detwiler, that means this identification is not real. It's not a valid identification. Because it doesn't return to a record in NCIC, where all of the state agencies basically will report their information into the database. So if there is a valid ID from a state, it should return to the NCIC. So it is now 9/29/34 when Luigi pulls the ID out of his wallet and hands it over to Fry. So then we go back to Detwiler's video, and he says it takes a few minutes to get a response on the validity of the license. And so it was from New York, or from New Jersey. He repeats, we see again, have you been up in New York recently? And the answer is, yes, sir, and kind of a sigh. And then we see Luigi like sitting there for a while, and then he goes and reaches for his food. At 9:30:22, he asks, what were you doing in New York? And he does not get an answer to this. Luigi doesn't answer him. So at this point, Detwiler asks him to stand up, put your hands on your head. He says this multiple times, put your hands on your head, and he's grabs him by the hand, and he has one of his hands, and he's like making him, put his hand up in this position. And while he's doing this, he says, "You seem nervous. Why are you nervous? What are you nervous about?" He doesn't get an answer to that either. So he does a frisk and then sits him back down. He asks Fry want to talk to him for a second, and then he walks away and leaves Fry standing there with Luigi. And so at this point in time, you see that the kind of configuration of how things are. Luigi is sitting in a corner. So his back is he's got a wall to his left, he's got a wall to his back, the table is in front of him, there's chairs on the other side of the table, there's a chair to his right, and then to the other side of that chair is the aisle where you walk out. And so somebody is always standing in that aisle. Like that's where they approach and where they position themselves. At least one of them at all times is standing in that aisle area. And this is something the defense is going to emphasize because they're trying to point out he, would have had to like push past you if he's going to try to leave, if he's going to try to end this encounter. You were blocking his exit to be able to do that. Detwiler explains he did the frisk to make sure that the defendant had no weapon. Because he knew that New York hadn't found the firearm, and he knew that a firearm was involved in that crime. It had not been recovered, and he thinks he's dealing with the New York City shooter here. So that's why he did the frisk. He had several layers of clothing on. The coat was very puffy, and this kind of came out of the blue at the time, but it comes together later when he explains that he did not find a pocket knife or a jar of peanut butter during this frisk. So he when he walks away, asking Fry, to step in and talk to him, he walks out of the side door, and his goal here is to make a quick phone call. So then we switch back to his own body camera at 9:30:55. He's outside. He's making a call on a cell phone. We find out later that this is to Lieutenant Hanley. So he's calling for backup. He says, "Can you come this way?" It's to 120 from 6, which is basically their unit numbers. He's 106. He's asking for 120. The officer in charge that day was Sergeant Thompson. So he contacted Sergeant Thompson on the radio, but he didn't get an answer. So then he makes this cell phone call over to Lieutenant Hanley, who he calls Tom. So he calls and tells Tom, it's him. Yes, he's here. It's him. He's not talking much. He said he was in New York recently. I'm sure it's him. So he's asking Tom to come down. He said he told Tom that it was who they were looking for, and that he appeared nervous. Now, when he described this in his police report, he says when he asked the man if he had been to New York recently, the man grew quiet and began to shake, right? So it sounds like real, like a real big tell. Well, you do not see any of that on the camera by any means. He got quiet, like he was never talkative. He never actually said much at all. So there was no transition to getting quiet. He didn't even acknowledge in his report that the man initially said, yeah, I have. But now he says, well, he saw his fingers shaking a little bit. His fingers were shaking a little bit. Okay, it's December, and he's maybe hungry. Like I don't know. This was a big backpedal, I thought, from the way that he described it in his report, which is kind of often the case. The police will describe things that they circumstances that they think are really super suspicious because they're trying to characterize it that way, but they often exaggerate or blow things up, and then when push comes to shove, they have to kind of acknowledge that maybe this was drama. They took a little bit of dramatic license in describing exactly what happened. So we saw that here. Now it's backpedaled from he got real quiet and started to shake to now his fingers were shaking a little bit. Like, what does that even mean? I don't honestly even know what that means. His fingers were shaking a little bit. So Hanley was surprised to get this call because Hanley had been the one who sent him the text message about "I'll get you a hoagie if you get the New York City shooter." So apparently they were both yucking it up, ha ha, not going to be the guy, and now they're surprised because Detwiler's telling him, "I'm 100% certain that it's him," as soon as he took his mask down. We go back to Fry's body worn camera at 9:32:10. And so now Detwiler is back in. They're having a little bit of like small talk. So now Fry is standing in the aisle, blocking the exit, and Detwiler standing across from Luigi on the opposite side of the table. So he asked him, "Are you from New Jersey?" And he kind of, Luigi is not real interested in having this conversation, but he's also not like telling them go away or fuck off or anything like that. So he's like trying to not like be real enthusiastic about chit-chatting, but he's a cop. He's not going to get the hint. He's going to do what he wants. So he just keeps pushing it, asks him if he's visiting family. Fry asked to give the dispatch the driver's license number again. So then he's reading the number back. Luigi is just sitting there in the corner. He's not moving. He's not doing anything. And you hear them, giving the driver's license number to the dispatch again. So now they introduce into evidence this big, massive blow up poster board copy of the New York City driver's license. It's probably maybe like 3 feet by 30 inches or something like that. I mean, it's this big, big poster board thing, very dramatic, the front and the back of the driver's license. They have it sitting up on an easel for most of this court hearing. And so, of course, you can see it's got Luigi's face on it. It's got the name Mark Rosario, New Jersey license. So he testifies, Detwiler, that he was relying on this document to convey the number to dispatch. It appeared to him to be real. It didn't like look like an obviously fake ID or anything like that. It looked like a real identification. At 9:32:53 is when Detwiler asks if he's visiting family down here, and he says, "No, I'm homeless." Detwiler says he doesn't know if that is accurate or not. He asks, "So have you been up to New York earlier or not?" And this time Luigi says no, and that's at 9:33:16. So nothing is happening now. He's called for dispatch, and for backup, and we find out he's basically just killing time because he's waiting for backup to get there. But he's trying to chit chat and play it off like everything is normal here. So he tells them, "We're just trying to run your ID and get you out of here." He identifies Luigi in person in court, does the whole dramatic, "Do you recognize the person that you had this contact with in McDonald's on December the 9th? Yes, I do. He's sitting right there in the black suit." Sometimes court really is like TV, not always, but sometimes it definitely is. So that was a little bit of the TV moment. That's the man. When he told him that he was just trying to run his ID and get him out of here, that was inaccurate. That was not, in fact, true. He was just trying to keep him calm and keep things normal and lead him to think he would be able to go. But he actually, at this point in time, had no intention of processing his ID and letting him out. So then we hear a voice in the background now, which is Hanley, who has arrived, Lieutenant Hanley, and he is now also, again, giving the ID card information to the dispatch. So this is like the third time now that this number has been sent back. This is the point where now Luigi is done eating, so he's wiping his mouth, sticking the napkins in the bag, and then he sits back in the corner and crosses his arms and takes his beanie off. We hear Detwiler say, "McCoy over here." So we know there are plenty more officers now who have arrived. "McCoy over here," wants him to stand where he had been standing so that he could go and talk to Lieutenant Hanley. So at this point in time, Detwiler had been positioned himself in the aisle area. He was standing between Luigi and his backpack. Haven't talked a lot about that yet, but the backpack on the ground. So McCoy takes over that position. He goes outside, and we hear Fry say, "That's him back there." Some questioning about, once again, how did you know? How did you know who this was and who you were looking for? And his explanation is, "We don't wear masks in Altoona. We have antibodies." So they knew. They knew apparently, like, not a lot of people were wearing masks. The description that had come in from dispatch was the person is in a blue medical mask. Apparently not very many of those because they have antibodies. And so he knew that had to be the person that they were looking for as soon as they saw him, because nobody wears masks there. So then again, as soon as he pulled down the mask, he knew this was the guy that executed Brian Thompson. Tells him, "Tom, it's him. I'm about 100% sure." They're having this conversation outside with a couple of them present. At that point in time, like before the backup had arrived, it was just the two of them. So they had safety concerns because they didn't know what was in the bag. They didn't know what he was going to do. That was why they called for backup. So now we're at 9:40 and 50 seconds, where Hanley comes into the scene and takes the identification. And at 9:41:07, we see. Okay, I got to explain that, like, this is jumping around a little bit because, like I said, they show us part of one person's video and then they skip to the other video, and so certain events we see like back to back from the two different perspectives. So we're back in the restaurant at this point. And we're now watching Detwiler's body cam. So at 9:40 is when we see Hanley come into the scene and take the ID and start to do the running the number again through dispatch. At 9:41 and 7 seconds, we see from Detwiler's body camera, we see him reach down and move the backpack. The backpack is on the floor, kind of by the chair that is next to Luigi. And so Detwiler takes the bag and pulls it away and then puts it on like the other side of him. So he stands then between Luigi and the bag. He describes the bag as being heavy. He said it was heavy. So we, once again, we've backed up. We're hearing Hanley in the background running the ID. We can see Sergeant Burns is present in the camera. He's making this hand gesture when you see him, and Detwiler explains that that's his communication, that he's asking if the man had been patted down for weapons, and Detwiler verbally responds, yes, he had. So now again, you have him, he calls McCoy over, says stand right here. So Hanley was the first to arrive after, it was just Fry and Detwiler initially. Then Hanley's the first to arrive. During his initial contact with Luigi, he never asked him about Brian Thompson. He never referenced the shooting in New York City. None of these things specifically. He asked him for his name and identification and where he lived, and if he had been up to New York. So there is a point here on the camera where he said, Luigi says, "What should I do next time?" And he understands this as kind of being like, how can I avoid having this unpleasant interaction with these cops trying to chit chat with me and run my ID and so forth. So they're just having this conversation. Then there's a break in the questioning where they're waiting for the ID from dispatch, where they're chit-chatting about where are you from, why are you in Altoona. He never told the defendant he was under arrest, never told him he was not free to leave. He didn't pull out the revolver. He did not mention the New York City shooting. So these are things that the prosecution is emphasizing because they are trying to downplay the significance of the restriction on Luigi's movements. And the reason for this is because of the Miranda requirements. So I'm going to go ahead and pause now from the recap here and talk a little bit about like what's at stake with this Miranda issue. So Miranda versus Arizona, landmark U.S. Supreme Court case from back in the 1960s, 1970s, somewhere in that ballpark, 1960s, I'm pretty sure. And it holds that when a person is being subject to a custodial interrogation, they have to be provided with these warnings. And the idea behind it was that this is a time frame where policing, they have moved away from like the old school, you know, having the billy clubs and like beating people into submission and stuff like that, at least ostensibly. And they have moved into much more psychological types of tactics to get information people, to coerce people into confessing and stuff. And so this is discussed at length in the Miranda decision. This is the time frame where like, oh, we're starting to develop the read technique and stuff like that. And so a lot of these techniques, they don't look like conventional torture or conventional pressure or things like that, but they can be extremely coercive. They can be things, isolation for a long period of time, sleep deprivation, withholding food, withholding water, just psychological tactics of yelling at you, lying to you, gaslighting you, telling you they have information that they don't actually have. Circumstances that don't just put pressure on you to try to give them what they want so that you can make the situation stop, but also that are really geared to like get you to question your own reality and start to accept, hey, if they're saying these things happened, then maybe that's true, and maybe I need to reconcile in my mind. If they're saying I did it and there's all this evidence, maybe I did do it. How could that possibly be the case? So these are the types of circumstances that the U.S. Supreme Court is just starting to be aware of, these kinds of police tactics. And so they're typically doing this, they've arrested you or they've hauled you in, they've thrown you into the interrogation room, and you're being subjected to this type of treatment. So that's kind of the context in which this rule came out. But so because of that, the sort of limiting factors on when police have to give you these warnings are based on those two requirements. It's got to be interrogation, meaning it's questioning that is intended to elicit an incriminating response to you. It actually doesn't have to be just questioning. It can be words or conduct. It can be implications. It can be like, police are driving you to the station and they're pretending to have a little conversation about, like, oh man, it's shame when people don't talk because such terrible things happen to them in court if they don't come clean. Yeah, I remember the last time the guy came clean to the prosecutor and he ended up getting a real sweet deal. They're not explicitly questioning the guy, but they're engaging in conduct to try to get him to think, oh, I should probably talk and incriminate myself. So that kind of thing can count. That's the interrogation side of it. What's going to be at issue in this particular case is the custodial side of it. So it has to be a custodial interrogation. It's not just any set of questions, right? Because police pull your car over and ask you for your license, ask you how fast you've been going, right? How fast were you going? You in a hurry? Those are designed to elicit an incriminating response, but they're not considered custodial for Miranda purposes. So they don't read you your rights before they ask you those questions. So custodial is defined in the Supreme Court case law as the degree of restraint on your freedom of movement that is associated with a formal arrest. And there's a lot of different kind of shortcut ways to look at this. One factor is a reasonable person in the situation going to feel that they're free to leave? But that's typically not the end point. And definitely in New York, I did some kind of preliminary research into New York case law to look at what their standard is. And that is one piece of it, certainly, but they're also going to look at under the circumstances, given that this is how this person, subjectively probably felt. Is it objectively reasonable that a person in that situation would think I am being restrained in a way that is roughly equivalent to a formal arrest? And so they're looking at things like, are you handcuffed? Are you, are you in a position where you can get up and go? Is there some kind of show of force? Is somebody pointing a gun at you? Stuff like that. So very fine line a lot of times between police are allowed to detain you for investigation purposes. This is Terry v. Ohio. This is a Terry detention, same justification to do a frisk. It's just based on a reasonable suspicion. They don't have to have probable cause to do that. But the idea is that it's a minimal restraint on your freedom, right? They're just going to stop you and not let you go on your way until they are able to dispel whatever suspicions that they have. And then, if they dispel them, you're free to go. And if they don't dispel them, then they're going to place you under arrest at that point. So Terry detention is kind of this weird gray area between you're not under formal arrest, but you're not really free to go. And so whether or not they're required to read you Miranda rights in the course of a Terry detention, it's a big gray area. It's going to be very much an it depends, fact by fact type of situation. Run-of-the-mill traffic stop is a Terry investigation, but by and large, they're not going to require Miranda rights to be read under that type of circumstance. If the detention starts to get a little bit more intrusive, a little bit more threatening, a little bit more, just looking more like you're under arrest than like you're going to be free to go. Maybe they've hauled you down to the station to ask you questions, even though you're not formally under arrest, but they're taking you down to the station to interrogate you. That's probably going to be more like a Miranda type situation. So I bring this up because what we're going to see over the course of this hearing is that the state is really trying to minimize the degree of the arrest, the degree of the restraint here, and the defense is really trying to emphasize it. So the state is emphasizing, hey, you didn't have your gun out. You didn't even say anything about New York. Like, he didn't know that was even on the table. You never told him he was under arrest or anything like that. You're just literally there to, run his ID and then telling him he'll be on his way. So state's trying to emphasize no reasonable person would think, hey, I'm under arrest here. Because the impression that has been given to him, according to them, is that we're just going to need to verify your ID and then you're going to be free to go. So now at 9:42, we see Detwiler going outside to have this conversation with Hanley, where he's telling him 100% positive it's him. So we see Hanley is standing over to the left, and then there's this other guy, Corporal Trent, who is a narcotics officer who's shown up. He's over on the right side of the frame at this time. At 9:43, Detwiler's saying it's him. I've seen all the pictures, and as soon as I asked if he'd been to New York recently, he got quiet. This again, not sure that that's really borne out on the video because he wasn't exactly chatty from the outset. So then we see Trent over here on his cell phone. He's pulling up pictures and like looking through the New York City shooter pictures. Detwiler's telling him, no, there's better ones than that. Like, apparently the one he pulled up wasn't good enough for Detwiler. So no, there's other ones. There's other ones that like make me think 100% sure it's this guy. So because he'd seen all of them. He'd seen lots of the photos. Hanley's saying that they released some new photos, but they don't have the guy's name, or if they do, it hadn't been released to the public yet. So we have our morning recess at this point, just a little break in the action. They take Luigi in and out of the courtroom during these recesses, so they stand him up, stick his handcuffs back on, walk him out. And this is pretty much the only time when I can see Luigi at all, because I'm sitting on the same side of the courtroom as him. He's on the right side of the courtroom with his defense team. I'm on the right side of the courtroom, way back in the back. There's 5 rows of press or whatever between me and him. So I really can't see him. I can't see what he's doing. I can't see what his expressions are. I can't see how he's reacting to this or anything like that. But this one opportunity when he gets up and is taken in and out of the courtroom is when I get to see him. So at this point, I see he does kind of do a look around to check out sort of the back of the courtroom. He has a very neutral expression on his face. He's not smiling. He's not frowning. It's just, kind of just taking in, what he's seeing. And he comes across as very polite and respectful to the court officers. You see him having like little interactions, you know, over the course of taking the handcuffs on and off and stuff like that. And just kind of noting he does not, you know, come across as like confrontational or difficult with them at all. Seems to be very, very respectful. So when we come back in after the recess, the prosecutor goes back to the video of the shooting, and he's going to try again to get this opinion out. This opinion. Well, did this seem like, remember before he had asked him, did this seem premeditated or spontaneous? The defense is like, no. And the judge is like, no. Well, he tries something real similar. Well, did this seem like maybe a professional shooting or more of a street shooting? What the fuck even is this question? Come on. Objection to that. That is also sustained. Give it up, dude. Like, court is such a show, don't tell, you know, type of process. If the judge can't watch the video and decide for himself what he thinks about it, then whatever you have a witness say it's not gonna matter. It's not gonna be particularly influential. If you think this looks like a professional shooting or, you know, premeditated or whatever, explain why, like from the facts of what we can actually see. But just trying to throw out this conclusory opinion, it's not impressive. Not impressive. But they're visiting this again because they want to get back to the threat. You know, they need to justify the actions that they took, the frisking, the going through the backpack, all that type of thing, based on, you know, we were very threatened. We thought there was a big risk to safety, public safety, our safety, because of the nature of the crime that happened, and because this is the individual that we suspect of committing that crime. So because of that, this is a, you know, real volatile type of situation, and we had to be on our toes. So they explained that Detwiler explains he thought it was a very high level of threat there in the McDonald's because it looked like the male that was in the video was lying in wait, and that he came up behind and shot him in the back. And he doesn't know how many times he saw this story on Fox News between the December 4th and December 9th, just that it was a lot. The whole shooting was very strange because we didn't know about any motive, but he was lying in wait to get behind him, and so it was just different. And the prosecutor is trying to get him to articulate a little bit better, a little bit more thoroughly, like, what do you mean by safety threat? Like, could you spell it out? He's trying to get to, I thought he might have a gun and pull it out, or I thought this was like, because this was political violence, he might, you know, do other politically violent types of things, and we're cops and maybe we're a target, like something. He's trying to get facts from this guy, but he's not the brightest bulb. Sorry, but you know, it's just often the case. He's not really a talker, not real good with his words. So he just keeps coming up with this, you know, well, I thought there was a safety issue because I recognized him. But he can't, like, you know, articulate what is the nature of the safety issue that you're concerned with. He remembered that there was the writing on the bullets, the deny, delay, depose, and it was an awful incident. And so when he pulled his mask down, I knew there was a safety issue for us. Again, just kind of jumping straight to that conclusion instead of walk us through the facts that you're relying on, because that's the Terry standard. Terry standard is based on an articulable suspicion. You have to have some facts. You don't just get to be like, well, I have a hunch that this is the guy, you know, or I have a hunch that there might be a dangerous situation. There have to be some facts that you're relying on, and so they have facts here. I mean, yeah, it was a shooting. The gun wasn't recovered. Possibility that the shooter still has the gun. If this is the shooter, possibility that he's got a gun. And if we're, you know, if he gets the idea that we're investigating him, he might consider himself threatened, and so he might do something desperate. Like, it's just not, I don't know, it's not that hard to use your words, but this guy just didn't have that. So he just keeps saying, it was a safety issue. It was a safety issue. It was a safety issue. It's about this point in time where we start to notice on the body cam footage that McDonald's is playing Christmas music, and McDonald's is playing a lot of old, like, jazz style Christmas music, and it starts to get real surreal, real just bizarre. We're hearing this very jazzy version of Walking in a Winter Wonderland now. It's like this upbeat, while this, you realize that you're watching somebody's last moments of freedom while the song is going on. So it's about 9:44 at this point in time, 9:44 and 53 seconds. They've had that conversation outside. They've been, looking through the phone at the pictures. He says there's some better ones. So they come back inside now. Hanley's on the radio with the dispatch. We see some other folks coming in and going out. When they come back in at about 9:45, Luigi's backpack is now up on the table. So somebody moves it up onto the table after Detwiler went outside. We don't know who, but somebody did that. So it had been on the floor behind them. Now it is up on the table behind them. So it's Luigi, the table, the chair, the alley with, cops standing in it. There's multiple cops there now. Another table on the other side, and the backpack is on that table. We see now, they go back. Detwiler goes back outside with Officer Fox. He puts his hand over his camera, and then he mutes the audio. So we talk about this because we don't get to hear this conversation that he's having with Fox. And so what's his justification? He says, well, sometimes we do it for administrative reasons. If we're having conversations that go to our strategy, like what we're going to do or how we're going to do it, then they mute the mic. He doesn't remember specifically what discussion he had with Fox that got muted, which is a little convenient, isn't it? A little convenient that he just doesn't remember that. So the prosecutor now brings out the policy and procedure that deals with the use of the body-worn camera and how to operate it, what the policies are, and so forth. So this is General Order 2.4. It's admitted as Exhibit 10E. On page 7 is the beginning of the body-worn camera policy, and page 11 is where we go to. Section G is on operational procedures. And so he reads out the policy. It says basically they should activate the body-worn camera and record all contacts with civilians. And they should always use the audio and video except where exempted by law or policy. And then we skip to page 15 where they have the exemptions. And the first one says there might be occasions when it is necessary to temporarily deactivate the camera. And the officer should be prepared to articulate the rationale. And they also say when reasonable, the officer should declare on the recording the reason why they are deactivating before they do that. And then they should also state when they are reactivating the audio. One of the subsections is for the exemptions is administrative conversations. And so he claims his version is that when they're talking about strategy, like what they're going to do, what kind of steps they're going to take, that those fall under administrative conversations. I don't know if I buy that, honestly. I really don't know if I buy that because administrative conversations are usually going to be things like schedules, lunchtime. We have a new policy that we're going to circulate. We need you to sign it and get it back to us by X date. That's normally what an administrative type of decision is. He is literally they're talking strategy, and that's field stuff. That is definitely not like what goes on back in the office. That's what goes on out in the field and why we're doing it and what we're going to do it for. And so part of the reason why this interpretation is a little troubling to me is because imagine a situation where we're talking about, like, for example, police are going to use force on somebody. Maybe they're even going to use deadly force on somebody, and they're having a conversation about it. And so somebody gets shot, or somebody, gets seriously hurt by police. There's going to be a lawsuit about that, and we're going to want to know, what was the process, what was the rationale, what was the decision making that led to police thinking it was appropriate to go hands-on or to use their firearm or whatever. And so interpreting this policy in a way that suggests, well, we're just allowed to mute all that and nobody ever gets to know. I don't really buy that. I don't really buy that as an explanation. So I don't buy his interpretation of it, but I also can't help but notice he didn't follow it anyway. He doesn't do the explain on the video, I'm going to be muting my mic now because we're going to talk strategy. Mute. Like, how hard is that? It's not hard at all. But he didn't do that. Nor did he, explain when he turned it back on. I'm turning it back on. We turned it off because we needed to have this strategy conversation. Like, nothing like that. So I don't buy his interpretation of the policy, but it doesn't look like he followed the policy anyway. Defense never came back to this. This was kind of a lost, I thought, a lost opportunity. I mean, it may not ultimately matter in the context of this particular hearing and what is going on with this hearing. But it might, because ultimately, when there is a warrantless search or a statement that's made without the benefit of Miranda, the burden is generally going to be on the state to justify that. They're the ones that have to show we did everything proper, we met the constitutional requirements, and so forth. So if there is a gap in information or an absence or a deviation from policy, that is often some good fuel for the defense to be able to rely on. Say, hey, they had the burden to establish it. They had the burden to establish they complied with their policy and so forth. They didn't do that. They needed to justify this conversation for whatever reason. The whole point of this hearing is supposed to be about risks and whether those risks justified the action that the police officers took. But if they're just going to be shutting off their conversations about the risks, then they're assuming that they're not going to be able to meet that burden, of establishing what those risks were when we come into court. Like, that's your trade-off. So lost opportunity, I thought. A little bit unfortunate. It was kind of served up there, a little softball like, but no swing was taken at that particular pitch. So they come back into the restaurant at 9:46:08. Of course, because Detwiler had his camera off. Once he turns it back on, there's no audio for a little bit. So we just see the bag is over on the table to the left. There's also something else on the table over there, but we can't really see what it is. We see a whole bunch of officers now. We get Yeager, Fry, McCoy, Trent, Fox, Miller, Lieutenant Hanley, like all mentioned, just identified, going through the screen, who's who. A lot of people right here in this area now. So this is, something that the defense wants to highlight, because it's one thing to kind of get up and walk your way past one cop, two cops. Now 10 of them are there. Is that's kind of starting to sound more like maybe you're under arrest, maybe you're not going to be, just having your name run and going home. Like, do they really need 10 cops here to verify your information? Just because somebody said you seem suspicious. Not real sure about that. A reasonable person might question what the hell is going on with all these cops here. So they had a conversation. Detwiler now has a conversation with Hanley, Lieutenant Hanley, and Hanley asks if Detwiler had given him the false identification warnings. So he explains that this means that if they believe someone has lied about their name that they've given to the police, they give them a warning that they're under official police investigation, and if they lie again, they will be arrested. This is based on the way that the Pennsylvania law is written for providing false information to a police officer. It has this requirement that you've been notified that you're under police official police investigation. So if they haven't given you that warning, you're not necessarily going to be. It's not necessarily going to meet the requirements to charge you under this Pennsylvania statute the way that it's written. So they have this process. They go and they give them the warning, and then if they lie again, they'll be arrested. But if they tell the truth, he says they usually don't arrest. Well, I would imagine not, because at that point, if they tell the truth, they haven't violated the law in Pennsylvania. Once they're notified they're under police investigation, if they tell the truth, that's not a crime. It's only if they lie again that it's a crime. But the false document is different. That is another charge, he points out. And so the warnings that they give don't undo that. So he goes up and he tells Luigi, you gave a false name, you're under official police investigation. If you give us a false name again, you'll be arrested. So then we go to Fry's camera. It's 9:46:40, and we see Detwiler asking, is that your name, Mark Rosario? Luigi says no. They ask, what is your real name? He says Luigi. And then a little pause, and Mangione, they ask for his date of birth, May 6, 1998. Fry is writing this information down. We hear Fox ask, why'd you lie about your name? This is going to be an important question, because this is kind of where the start of are we in a Miranda type of situation is going to be. Like, we're starting to be in a real good position to be asking if, hey, are we in a situation now where Miranda is being required? Because this is clearly intended to elicit something incriminating. One, it's an admission about lying about the name, but two, now it's also, asking to provide some kind of explanation, some kind of motive, so to speak, and particularly now because it goes to their suspicion that he's a New York City shooter. Why'd you give a false name? Oh, well, because I was trying to hide my identity so you wouldn't know who I was. Like, yeah, they're going to use that, absolutely, if they can get you to say something like that, because that would be consciousness of guilt. That's, I know I'm under suspicion. I know I did something, and the police are going to be trying to put me away if they can connect it to me. So that's why I gave you a false name. I didn't want you to know who I was. But what Luigi says is, I clearly shouldn't have. They ask him, why did you lie again? Fry is asking now, because they say, I didn't hear it. And but in the meantime, there's this interruption. Someone's asking him for his middle initial. He says N and then says it's Nicholas. So he responds with something like that you can't hear it real clearly on this particular camera, about why'd you lie? And he says something about that was a fake ID I had. And so they ask him, you had a fake ID, and he nods on the camera. So now at this point, somebody comes over and they read him the Miranda rights. Right? You've already asked him the questions. You've already asked him about acknowledging that it's a fake identification. You've gotten the incriminating information. Now you're going to read him the Miranda rights. It's going to come down to this custodial issue, because that is clearly interrogation at this stage. They already know what he's under suspicion for. He's under suspicion under Pennsylvania law for giving them false identification, presenting them with this false ID that ultimately translates into three different charges in the case. So if this was a custodial setting, when they asked him these questions, they are potentially going to have an issue, because this admission, yes, it was a fake ID, is potentially what gives them the probable cause to make that arrest. And so if they don't have probable cause to make that arrest, then they don't have basis to do a search incident to arrest. But we'll get to that. So ask him if he understood the rights. Yes, he understood them. So Fox is who read the Miranda warnings. Trent had told him to, and it was after he said, I had a fake ID. So the timeline is real clear about that. Fox asks him if he wants to talk to us, tells him, you're not in custody at this point. You're not in custody at this point. He's not handcuffed at this point. Now, what police officers say is, not definitive at all. It's one piece of the equation in determining if this is a custodial situation or not. You know, if police have you, they do the thing where like they don't formally arrest you, but you're detained, and they take you down to the police station, and they you know, stick you in the interrogation room and ask you the questions, and they tell you, well, you're not in custody. It's going to be for the judge to decide under all of these facts whether you're in custody or not. It's not up to this cop. The only thing this might have some relationship to is, so if you're an objective person in this situation, are you going to reasonably feel like you are free to leave or not? And so if the cop is telling you you're not in custody, well, does that mean I'm free to leave? You know, maybe that's going to be what the state is going to try to emphasize here. So now we're at 9:48 and 57 seconds, and Luigi's being told, anything you give us now that's fake, you'll be arrested for it. Because now he's under official police investigation. We go back to Detwiler's camera at 9:48, and we hear this now a little bit clearly, where he's asked, why do you lie like that? He says, I clearly shouldn't have. And then Detwiler says, I couldn't hear what you said. He walks into the bathroom and walks back out. We then hear Corporal Trent saying, take him into custody. He did say it was fake. So that seems to be a little bit of an admission on the part of the police right there, that statement is what gave them the probable cause to find that this was in fact a fake ID. Without that, it was a false name, and it was an ID that wasn't showing up in NCIC. But that doesn't necessarily mean that it's fake or that it's been altered. You know, things do happen. NCIC is far from a perfect system. Oh Lord, there's all kinds of errors in it. People get mistaken for other people. You know, like I've had situations where, because you know, people share the same name, not all that infrequently, and so I've had situations where, like, you know, I'm going up on a bail hearing or a sentencing or something like that, and the state is arguing that my client has all of these convictions, these prior convictions and arrests and things like that, and my client's like, yeah, no, absolutely not. I've never even been to that state, and it's because they have them mixed up with somebody else who's in the NCIC. So it's not a perfect system by any means. It's a piece of information, but is it proof beyond a reasonable doubt? Is it even probable cause? Maybe probable cause, but it's definitely not going to be proof beyond a reasonable doubt that this is a fake ID just because it's not an NCIC. So Trent says, you know, he did say it was fake, so take him into custody. That seems to me to be an acknowledgement. This is what gave him the probable cause. So they tell him to stand up, turn to the wall, put his hands up. They frisk him again. It's 9:50 now. We're back watching Fry's body-worn camera. So he's got his hands on the wall. They ask if there's anything in his pockets. He says no. They frisk him. He says, I do have a pocket knife. And he apparently said something about a jar of peanut butter in his pocket. Detwiler had not found either of those during his first frisk, right? Quite a frisk you have. You couldn't find a jar of peanut butter in there, let alone a knife. A knife. Like literally what the frisk is for is to try to find a weapon. He didn't find it. But, you know, he had several layers on, right? That's why he had at least 3 layers on. So now at this point, he is handcuffed. They're handcuffing him. He's following all directions. He's very compliant. He's not fighting with them at all. We're listening to I'll Be Home for Christmas. I'll be home for Christmas. Really surreal. Really surreal. So somebody says, detain him. We hear on the camera somebody at this point saying, detain him. And so he explains, well, that means that he's not free to leave, but he's not in custody. That seems to be in conflict with what Trent had just said before, where he said, take him into custody. He did say it's fake. And that's when they turn him and start arresting him. So there seems to be some confusion on the part of the police about exactly what his status is. And I don't know that that confusion is going to work in their favor, right? Because remember, they're the ones that have the burden of proof. If they're going to justify a warrantless search, questioning without the benefit of Miranda, they're the ones that have to justify it. So You got one person saying take him into custody. You got somebody else on camera saying detain him. So Detwiler explains, well, you know, he's not free to leave, but he's not in custody. This is a Terry situation that he's describing. Custody means that you're being arrested for something. Detained means you're under investigation and you're not free to leave until it's done. And at that point, you can either be in custody or you can be released. So really trying to kind of set the stage, open the door here for the state to argue this was just a Terry detention, even at this point in time when they have him handcuffed and stuff like that. It doesn't mean he was under arrest yet necessarily. So then it's 9:49:06. We are kind of rewatching all of this again on a different, you know, different camera. We're on Fry's camera now. We see Burns and Hanley and Trent. They're all talking apparently to people at the DA's office as well as people from New York City. This is kind of interesting because we're going to run into a little bit of an issue about what law applies here. And the more that New York City is involved with what is happening with Luigi in Pennsylvania, the more likely it is that there's going to be a conclusion here that New York law applies. We'll talk about that in a little bit. So Hanley then gets communication from dispatch saying that they found his name in the NCIC, meaning presumably Luigi Mangione's name. So Trent then asks if it was his stuff on the table. Detwiler says, yeah, I pushed it away from him. He reiterates that Hanley was talking to New York. He was talking to their DAs there in Altoona, Pennsylvania. They're identified as Pete Weeks and Nicole Smith. At 9:53:35, Patrolman Wasser has the fake ID. This is the woman. This is the woman patrol person. She's got the fake ID. You can see it in the camera. Fox then says that's the guy who checked in at the hostel with that ID. They're back outside, and then at this point, Detwiler mutes the camera again. That's the guy that checked in at the hostel with that ID. Well, they got that information from New York, right? This seems to corroborate that they're having some conversations with investigators, whether it's the NYPD, whether it's the FBI. It's somebody with inside information about the New York City shooting, because that's not public information. It was not public information that the person who checked into the hotel used this Mark Rosario ID. So they were in contact with NYPD or FBI at this point. This is not going to be a helpful fact for the state. We'll talk about that. So again, he mutes his camera, so we don't get to hear the rest of this conversation, which again is going to be a little bit troubling given the context. So now we go back to Detwiler's body-worn camera. He tells us the decision has been made to arrest Luigi at this point. That decision was made by Lieutenant Hanley. He did it after conferring with the DAs Weeks and Smith. And so he was then arrested specifically for forgery. Forgery of a fake identification, which is a felony, and then also the false identification. So according to him, those were the charges that were levied at the time. So we see him approaching Luigi. McCoy is now cleaning up the table, and Luigi is placed into custody. So this is 9:58:12, like a couple seconds before, where they, start telling him being placed into custody. Detwiler starting to put on gloves. You see him putting on some black, latex or whatever material type of gloves, nitrile. And he explains that's to search his person, incident to arrest. This is something that is always done when somebody is arrested. So we see on the camera, he's on the left, Fry is on the right, McCoy is in the middle. So they're all surrounding Luigi at this point. Fox asks him if there is anything in the bag we should know about, and we now see officers starting to go into the bag. So we see Detwiler remove this blue item from the jacket pocket. He describes it as a wallet type case that was holding money and cash inside. It appeared to be a lot of cash. There was also foreign currency in it. And he removed that item from his pocket and put it inside his beanie, which is essentially what they are using to kind of collect everything that they recover in the search. They stick it in that beanie. We start to see McCoy unzipping the his second layer. He's got like this large outer coat and then like a thinner undercoat and then his undershirt on underneath. This is 9:59:17. We are now listening to Holly Jolly Christmas. It's a Holly Jolly Christmas while this is going on. We see somebody removes this little small piece of paper from the jacket and puts it over next to the hat. He says he puts it in the hat, but it's actually sitting there next to the hat. Just, you know, the precision, the focus on details doesn't always matter to the police that much. They'll say what they feel like they need to say, and then you can see with your own eyes on the body camera. That piece of paper is not actually inside the beanie where you said you put it. It's like sitting right next to the beanie. So I don't know whatever happened with that piece of paper. I'm not sure if that ever made it into evidence. I'm a little bit curious about that. He took some change out of his pocket, put that in the beanie, and the goal of that is to keep all of his stuff together. So at this point, it's a little after 10 minutes, 44 seconds. We can see now in the background of the camera, Wasser is going through the backpack with Fox. And so this is after his arrest, and that's important from a kind of timeline perspective, because it's going to go to what is the justification for doing the search without a warrant. And it seems pretty clear that they are going to rely, at least to some extent, on the search incident to arrest exception. So let's talk about this now, because this is what is ultimately going to be, you know, one of the critical issues in this motion. So general rule under the Fourth Amendment prohibits unreasonable searches and seizures unless there is a warrant. So presumption is if there's no warrant, it is unreasonable. But, you know, rights are never absolute, even though, you know, they might be written that way, but the courts don't tend to see them that way. They find lots of exceptions for those, and particularly the kinds of exceptions that tend to protect us individual people from the behemoth of the government, the police state, and the conviction production system that we have that goes on in our courtrooms. They'd find more and more ways to chip away at that. So there's a number of exceptions to the warrant requirement, and one of those is the search incident to arrest exception. What this is basically what they're saying. It's predicated on considerations of officer safety and the risk that you know, somebody could rapidly get rid of some kind of important evidence in the case. So, you know, the kind of classic example would be, oh, somebody has a little bag of drugs on them. We arrest them and we don't do a search. You know, then they might, you know, grab it and swallow it, and then it's destroyed. That's going to be dangerous for them. If they maybe have a weapon hidden somewhere, we're going in to arrest them. They could grab the weapon and cause us some harm and escape, things like that. So because, you know, a person who is being arrested knows they're being threatened with the loss of their liberty, the idea might be more inclined to do something dangerous to get out of that situation. So police are then allowed, when they have arrested somebody, to do a search of their person and the area within their immediate control. And this comes from a case called Schimmel. And again, it's just based on this idea that, you know, if something is within distance where you might be able to get to it, it could have a weapon, it could have evidence that you could, you know, swallow or get rid of or whatever. And so it's protective for that reason. So generally speaking, it means they get to now search your person thoroughly. A Terry Frisk, a pat down, is supposed to be a limited pat down of your outer clothing to look for weapons or contraband. They are not supposed to be like reaching into your pockets. They're not supposed to be palpitating things to be like, ooh, I feel something here. Let me feel it a little bit more clearly and see what it is. Is it, is it a gun? Is it a pack of gum? Whatever. Not supposed to be able to do that. But a search incident to arrest, now they are allowed to do that. They're allowed to go into the pockets. They're allowed to remove the stuff, look at it, make sure that there's no dangerous or contraband type of stuff in it. Then it extends to the area in your immediate possession, and that can include, like if you got a bag, you got a purse, you're sitting in a car, right there in your passenger compartment is sometimes going to be subject to search. Now, the issue is we have this U.S. Supreme Court standard that comes down that's based on the Fourth Amendment, but that's really the floor of what the law allows. That's not like the ceiling. States can have more stringent requirements if they want to. And so many states do, in fact, have more stringent requirements to do a search incident to arrest. New York seems to be one of these states. New York recognizes that the whole justification for this has been, it's an emergency type of situation. There's exigency involved. This is particularly volatile. And so the search incident to arrest needs to be constrained to that. Meaning that if there's no evident risk or no evident danger, the search isn't going to be justified. If a person is handcuffed and they're in custody and there's no item that is within their reach, you don't have an exigent circumstance that justifies you going in and getting this, getting into this bag or whatever without getting a warrant from a judge that says, yes, you have probable cause to look, and here's what you have probable cause to look for. And it, kind of circumscribes the areas in which you're allowed to look based on what it is you're looking for. If you're looking for a gun, then you don't get to look in the coin pouch that isn't going to fit a gun in there. So warrants give you lots of protections. Those protections are thrown out the window if they don't have to get a warrant. So New York has a much more protective standard for these searches incident to arrest. That is why the defense, when they filed their motion to suppress, argued this motion based on New York law. They're arguing the backpack is way over here. It's out of his reach. There's a bunch of cops in between him. He's got handcuffs on. There is no realistic danger that he's going to be able to get to that backpack and get something inside it without, being immediately tackled and tased and God knows what else they would do in order to prevent that. So they needed to get a warrant under the New York standard. I think this is a pretty decent argument. It gets even stronger because we ultimately see Luigi is being led out of the restaurant, and the backpack is still back there in the corner, and they're still going through this backpack. Okay, Luigi's gone now. There is no chance he is getting into this backpack anymore at this point, but you're still over here rifling through it. So if it's going to be justified on exigency, that's going to be a little bit of a challenge. But here's the thing. This arrest is taking place in Pennsylvania. It is being done by Pennsylvania police officers. He is being arrested for a Pennsylvania crime. They aren't arresting him for being the New York City shooter. They're arresting him for this fake ID that he gave them. So does New York law apply here? Is New York law going to be what applies here? That's going to be a really important question. And it is not anywhere near as easy to answer as you might think. Like, I know people often like to think the law is really super cut and dry and it's black and white and it's really easy. Something is within the law or it's not within the law. Rarely is that the case. It's like, that's why the joke is that the lawyer answer is always, it depends. Ask them any sort of question about, is this legal? What's the law say about this? The answer is always going to be, it depends. This is getting into choice of law, which is, it can just be a very complicated, very complicated area about what law actually applies in a given situation. They want to use this evidence in a New York court. And so that is going to be a strong legal argument for New York standards need to apply. And the best way to understand that is to kind of take the situation to the extreme. Like, let's imagine an extreme situation. We're in Russia. Russia allows police to come in and beat you and take your things and go through them without any kind of legal process or even necessarily suspicion. I'm not saying this is true. I'm just, using this as a hypothetical example. They do that. They do that in this case. Luigi is not, in fact, in Altoona, Pennsylvania, in McDonald's. He's in Russia, and the KGB runs in and grabs him and beats him with the billy clubs and takes his backpack and starts going through it. Why? Well, just because they don't like how he looks. He's some American. He's out there. He's got dollars. They just decide they're going to try to see what they can get from him. It's perfectly legal in Russia for them to do that, hypothetically. Does that mean they can use that in a New York court? That would be pretty appalling if that was the case, right? We have to have some kind of floor for when we allow evidence to be used, or we don't really have a principled constitutional standard. You're just basically saying, if there's some workaround from some other place where they can, do things that we would consider extraordinary violations of your rights here, it's going to be okay if we want to take advantage of that and exploit that in a U.S. court. That's really contrary to the whole fruit of the poisonous tree doctrine that the suppression of evidence is based on. So I think it's real easy to see in that situation, no, court's not going to let that in. Of course, the court's not going to let that in. You can't be like, oh, well, he was beaten, but whatever, Russia's cool with that, so we're cool with that. It's just not likely to happen. So this clearly isn't that situation, right? But it does seem to be a situation where the Pennsylvania standard to do a search incident to arrest is a little bit more favorable to the police. The Pennsylvania standard is just, when you're arrested, you and the items in your immediate possession, they can be searched, and that can include bags. So it's not as bad as beating you and stuff. It does probably meet that Fourth Amendment floor. It's not, obviously unconstitutional under the federal standard like the Russia situation would be, this hypothetical one. But nevertheless, it doesn't meet the standard of what they're allowed to do in New York. And then you start thinking about well, what does this mean in terms of the incentives that you create for police and things like that? What if we're on a pursuit? We're pursuing somebody, and it's maybe a kind of a dangerous situation, but I know that if I wait until he gets through the Holland Tunnel and comes out in New Jersey, there's going to be a different standard that applies over there. So I could just wait and then arrest him over there, and then I can do things that I wouldn't be able to do if I was back here in New York. You create incentives then to exploit these loopholes. So it's going to be a interesting, I think, and potentially very complicated legal issue. There is not a whole lot of law out there on this. I have actually to share, thanks to Corey Hopkins, the fabulous Marbury versus Madison, incredible lawyer. She came up with this late last night and shared it with me. But this is just some of the cases from New York on this particular issue that kind of come down in different places depending on different factors. The misconduct occurred out of state. Who has the greater interest in regulating that? But the crime occurred here. We want to use the evidence here. That means New York has a greater interest in it. So it's not a situation. Oops. It's not a situation where there is a real crystal clear answer that's already set up. That means this is kind of a novel legal question, and novel legal questions are fantastic. I mean, to some degree anyway. They're good for criminal defendants because they are ripe for appeal, and they're also ripe for appeal up to the highest levels of the court. Not a situation where, you have some trial errors that you can argue, but they're fairly routine, fairly easy to apply existing standards. So those don't typically get the attention of the high courts. And issues like this do, because it's open questions. It's not really clearly established. And so the courts that are at the highest levels are the ones that tend to consider these high level policy issues. Like, what are police going to do if we accept this rule? What's the implication going to be for our ability to prosecute people when people are acting in good faith in another state under their own laws? Like, there's a lot of stuff to weigh here. So that's good for a defendant because it gives him a good issue on appeal that can potentially go up to the highest levels of the court. That was our little search incident to arrest choice of law segue. That I spotted this when we did that live stream going through the motion to suppress, and I kind of saw that. I remember I had like a little side comment like, oh, interesting. It's all in Pennsylvania. I wonder what law is going to apply. I didn't really expect it's going to come front and center, but it is. It's very clear that the state is going here, and we'll see that more as we get a little bit further along. So we're right about halfway through the notes now, guys. So they asked him, remember, is there anything in that bag that we need to know about? And they don't know what, if anything, Luigi said in response to that. We see Fry taking some gloves out of his jacket, put in the beanie. The beanie's ultimately taken. Detwiler took it from McDonald's to the station. They remove a blue item from his right pocket, which turns out to be a big jar of peanut butter, which he, again, did not find during his first frisk. I mean, I suppose you could maybe mistake a jar of peanut butter for like a hip bone or a rib or something like that, but yeah, seems a really big thing to overlook, but whatever. They pull out a rolled up piece of string or rope, stick that in the beanie, and then we see Luigi is being taken out of the McDonald's, and Wasser is still searching the backpack at this point in time while they're walking him away and leaving. So we know from the description in the probable cause that, according to Wasser, she stops searching as soon as she finds the magazine. She sees the magazine, she spontaneously says, oh, I need to make sure there's no bomb in here. And it's at the point that they find the magazine where somebody, I think, speaks up and says, "Oh, we probably need to get a warrant now." Maybe you needed to get a warrant before, but now they're like in the oh shit, need to CYA here, need to get a warrant. So they stop the search when she finds the magazine. So what this tells me, they're walking Luigi out, they're still searching, they haven't found it yet. So if the exigency of the situation is based on Luigi could possibly get to it and get something out of it, okay, let's say we'll recognize that yes, people can fight out of the handcuffs, people can lunge, people can do things by surprise. Maybe he could get to it when it's just right there. But by the time he's out of the McDonald's, that rationale is gone. It's just that's not going to be feasible. So if they haven't found it by the time he's left the McDonald's, it's going to be difficult to challenge, to establish why there is exigency for you to continue the search to the point that you ultimately find this magazine. At this point, we take our lunch break. So we get about an hour for lunch, which is nice and leisurely, certainly compared to the old days back in Delphi. actually have time to get food and eat it. Like who would think? How humane. So when we come back after lunch, we have a little colloquy before the witnesses were called. The state wants to be able to use a laser pointer on the screen. The judge is like, that's not going to work, but they have some like drawing capability with their technology. And so they say, you know, that's fine. The second chair prosecutor will handle all that. They don't ultimately end up doing anything. So I don't know what the concern was, but they also wanted to clarify if the defense had withdrawn objections as to Sheriff Ott, because he wanted to call off his travel plans if he didn't need to be there. I'm not real sure what this was. The defense had filed a letter right before this hearing got started, and I believe it's in there, but I just don't remember off the top of my head. So anyway, the defense then speaks, and they agree that they are withdrawing a challenge to statements 11 through 13 that were from Sheriff Ott. So what this sounds like is that these are additional communications that Luigi had with the sheriff. Don't know what they were. I don't know what the substance of those are, but they are no longer challenging them. They're not subject to the hearing. So those statements then will presumably be admissible if there is a trial in this case. The defense also confirms they are not challenging the authenticity of the body cams for purposes of the witness who is testifying about what is on each body camera, like what is on their own body camera, because they personally witnessed those things. So the court's saying, well, but there has been a foundation that they reviewed all of the body cams. Detwiler reviewed all the body cam footage, and it is accurate. And the defense is again saying, well, but they only know that. They can only attest to that if they were present for it. And the court says, well, you know, we walking in and out 2 times doesn't affect the admissibility of the body cam. So he's just kind of flat out rejecting that particular objection to it. He's clearly gonna allow it in without all of the officers. You know, each officer who had a body cam that they wore having to come in and testify. Now, some of this is likely because they have like diminished standards for the admissibility of evidence in these pretrial types of hearings. It doesn't always have to be the same quality of evidence that you would expect to have at a trial. Hearsay, for example, generally going to be allowed in these types of hearings. And some of it's also likely just for efficiency. He doesn't want to take the time to call in each and every one of these officers to lay the foundation to introduce each and every body camera footage. He doesn't want to have to take the time to do that. So he's gonna, just basically find a way to say that it's not necessary. So we get Detwiler back on the stand at this point. He has reiterated every body camera several weeks ago, looked at it on the computers at the station. He confirmed that the timestamps are accurate. Now he lays the foundation for this to be a business record. So a business record is an exception to the hearsay rule. It's when a document is kept and maintained in the ordinary course of business, not in preparation for litigation, but just ordinary business type of record keeping. It's made at or around the time of the events in question. Then it's kind of presumed to be reliable, and so it is just one of the standard exceptions to the hearsay rule. So they reiterated that he had, reviewed all of the cameras. They were all accurate. The defense now asked to voir dire again, and they ask him, how many of the cameras did you review? The state objects to this being beyond the scope of what a voir dire is there for, and the defense explains. He said, you just asked him. He said he reviewed other people's footage. So they allowed the question. Then as to the Fry's camera, again, established these are business, maintained in the course of business of the Altoona Police Department. He's reviewed them all. And defense voir dire, again, you don't appear on, like there's 5 separate videos from Fry. You don't appear on the last 2. You weren't present for those events. So he says, I was there. And then he says, well, I don't remember exactly what was then. Maybe and then no, I wasn't. So he's trying really hard. He's trying really hard to place himself at the scene for what was depicted on these last two pieces of body cam footage. Like, that's his knee-jerk thing, is to just, yeah, he was there. Yeah, he's a witness. And he actually has to think it through and remind himself, oh shit, like, I guess I wasn't. I guess I have to say no. I'm probably going to be able to be caught if I lie to the court and say that I was, because they have the freaking video, dude. Like, they have the video. They're going to know. They have the reports. They're going to know. But he sure was, willing to knee-jerk go there until he had to correct himself. So the defense states that they're objecting to the last 2 videos of Fry because he wasn't there. The state says that they're a business record. The court says they are allowed as business records for this hearing. And the defense states they are not business records for a number of reasons. Well, I have to say, I think that the defense is right on this one. They don't qualify as business records. The main reason is because you have a couple different levels of what's going on here when you're talking about hearsay. Hearsay is an out-of-court statement offered for the truth of what is asserted. So somebody out of court said, Luigi shot Brian Thompson. You don't get to introduce that in court without bringing that person in to testify so that they can be subject to cross-examination. It's hearsay to just bring it in without, like in an affidavit or a cop saying this person told me or something like that. Body cam footage contains a massive amount of hearsay, right? You are video recording conversations. So the video itself is hearsay because it's essentially treated like a document. It is a, it is a depiction of something that's taking place out of court. But you have people on the video saying things. And sometimes they're saying things based on what other people told them. And so each of these is a level of hearsay. And so you have to have a separate justification for each level of hearsay that you're getting into. So I looked this up a little bit as well for New York law last night. And New York basically says, yes, in some circumstances, police reports, police footage, things like that can be considered business records, but only if the individuals who are speaking on that body cam are available as witnesses who are going to be there to testify. It's that second level hearsay. So the way that that's going to apply in this situation is, okay, we could say that the video itself is hearsay, but if Fox, Yeager, Hanley, all these other cops that are present are not coming in to testify at this hearing, then what they say on that camera is hearsay. And when they are relaying things like dispatch told me, or whatever the information that they got from other sources, that is also hearsay. So that's going to take it out of the framework of qualifying as a business record. So I do think that the defense is right on that. That said, it's not clear that they actually have to meet a hearsay exception for these videos to be admissible in a pretrial hearing in New York. So it might just be kind of a moot point that they were trying to establish it, but it's not actually necessary that they do. We move over to Yeager's video. That's why this matters, right? Because the state is now getting every single body cam is now in evidence. They can rely on them. So we have Yeager's now. Yeager's not testified. We haven't really heard much about him at all. But his camera starts at 9:57:45. It shows McCoy starting to clean up the table. This is while they're placing Luigi into custody. Winter Wonderland is playing. and they're placing him into custody for the forgery charge. You can see the backpack again being searched in the back. It looks like at some point Wasser, the female who is going through the backpack, hands something to another officer, but it's very quick and hard to see, so that was not really that clear. He is asked how much distance is between Luigi and the bag that's being searched. He says 2 to 3 feet. Now, we all have eyes, dude. We all have eyes. Like, could you just not exaggerate just once? Like, the thing that's so frustrating about this is because it's so undermining of his credibility, right? If you can't give me a straight answer, like knowing that I can look with my own eyes at what is happening on the screen and see for myself that it is at least 5 to 6 feet. Okay, it is not 2 to 3, not even close. Then how am I to trust you to tell me correctly and accurately about these other details that I can't verify for myself? I mean, you're literally willing to lie to my face about what I can see for myself. So it's very frustrating because the lack of credibility is clear, but judges will almost never find a cop to have no credibility. They will almost never do that. Like, you have to have them so explicitly caught in a lie that they can't talk their way out of to get that type of finding from a court. And you know, there's a lot of reasons for that. There's political reasons involved. There's just like the familiarity, you know, a lot of times they work with the same cops, you know, over and over. There's the incentive factor that if a judge finds a cop to have lied, that cop is now tainted as a witness in court. That's going to be Brady. It's going to be a Brady issue. It's going to go to, you know, the ability to impeach him in future cases he testifies in. So they don't want to do that. So they will bend over backwards to find the least credible cops perfectly believable, you know. And it's especially frustrating in situations where then you have your client testifying and maybe your client has friends testifying, you know, and they're all like, what the hell, and their story makes perfect sense and the cops doesn't, and the cops and the judge is like, well, this defendant and his friends are clearly all lying. And it's just it's really frustrating because credibility of the witnesses is one of these things that the judge or the jury, depending on who's finding the facts for this particular process, they have ultimate authority. Like, it's untouchable. It's not reviewable. It's not appealable. Courts of appeal say they will always defer to the fact finder. They will never second guess, because the Court of Appeals isn't in the situation of observing the manner, the demeanor, how they're testifying, the tone of voice, things like that. Like, that's somehow more telling about credibility than just the sheer nonsense that's coming out of your mouth. So this is just one of those areas where the legal standard, I mean, I understand it, I get it, but I don't really think it necessarily makes a lot of sense 100% of the time. And how it actually ends up playing out in court, I think is very unjust in a lot of different situations. So this was just a situation, like, it's obviously not true that it was 2 to 3 feet. We can all see it for ourselves, but the judge is still going to find this guy credible. Just, you know, predicting that, laying that down, that marker. Don't expect a finding that that this cop lacks credibility. So then we go to McCoy's body-worn camera, again, starting at 9:57:45. We're just looking at all these different angles of taking Luigi into custody and, you know, showing the same thing. Wasser putting on the gloves, starting the search of the backpack, removing the little piece of paper from Luigi's right front pants pockets, the brown beanie with his belongings. We then see them, McCoy is like behind them, so we're watching Detwiler and Fry. So they're leaving the building. They put Luigi in the back seat. From there, they transport him to the station. On the way to the station, he asks them for their names. They give their names to him, Detwiler and Fry. We then move to Fry's video at 10:10, showing them pulling into the police station. Take him out of the cruiser. His coat's like kind of falling off his shoulders when they take him out. And of course, his hands are cuffed behind his back, so he can't do anything about it. So they're pulling his coat back up, which seemed nominally courteous, I suppose. They get inside. So they park way out in the parking lot. You know, they seem to be places they could park right next to the building, but they didn't. They parked like way out in the parking lot. So they walk and walk and walk and walk and walk and walk like across this long parking lot, probably, you know, 3 rows of parking spots to get to the front door of the station. But they eventually get inside. They put Luigi on this like kind of stand area, tell him to take off his shoes. He's faced to the wall. They have a shackle, an ankle shackle that they attach to him. So he's now, you know, shackled to the wall by his ankle. There's some stuff on a desk next to this area. He identifies this as the intake area. It's got blank, what he calls R&I sheets, some bags and things like that on the desk. The R&I sheet is, it's got questions about his belongings and his personal items. So I don't know what R means, but I suggest I means inventory. It's just a standard form that they have. This is going to be one of their second justifications for the backpack search. They're going to argue potentially that it was an inventory search. So the form potentially goes to that. So they cuffed his foot, his ankle to the floor. Fry has the beanie with him, so he then empties the beanie out onto the desk. We see Swope now, Deputy Chief Swope and Detective Houston are standing kind of over behind and to the left. They ask his name again. He repeats Luigi Mangione. There's another prisoner at the station right now who is apparently being taken to the hospital, and he is making a lot of noise. So there's a lot of background noise that's going on while they're having this conversation. But they're talking about his name and his identification, and Luigi says they have the passport. It's in the bag. So he explains, Detwiler explains that back at the station now they are, you know, trying to ID him. That they try to use their ID if possible, and that he said his passport was in his bag. Another potential factor dropping in to suggest, oh, he gave them permission to get into the bag to get the passport. So then once they're in the bag with, you know, looking for the passport, anything that they find on their way looking for the passport is potentially in plain view. They're not violating his rights by going in if he gave them permission to do that. So that is potentially going to be another justification that they offer. I'm still a little skeptical of this one too, though, because they already got his name and confirmed it through NCIC. So I don't know why they need to do this again. What the justification is. You already confirmed, you already got his name and confirmed that that's a real person. But I don't know. That, he says, is their policy, that they're looking for the identification. We then go back to Detwiler's camera, watch the same thing, see them walking him into the station. Stand here, take off your shoes. We see a bunch of lockers, and Detwiler identifies those as places where the personal property of prisoners is kept. So then if they get released, they take it with them. And if they get transferred to some other facility, like they, you know, get a prison sentence and get taken to prison, then they take it with them on the transport and give it to the correction officers. You hear someone saying he gave us a name, Luigi something. And then again, Luigi saying they have the passport, it's in the bags. He claims that they do this in every case, asking for identification. And it's related to this form that they have that asks for the social security number, the birthday, are you right-handed or left-handed? These are all standard questions. Do you wear glasses at all? All standard questions. And at this point, he left the area. So Detwiler is then shown a series of photographs. There's one of a laptop. He says he recognizes the computer. It was at the table that the defendant was sitting at. There is another item in the photo that he doesn't recognize what it is. We see the photo and we see it's, you know, a silver Macintosh computer, and something else, like maybe it's like a case, like a cloth cover, a bag or something like that. It's very hard to tell what it is from our perspective in the courtroom. I couldn't really tell, but it was a laptop, MacBook computer. Photo of a wallet that was taken from his pocket that had some money in it, but this was not a ton. This was like a normal, you know, cash. Saw like a 20, 10, ones, you know, just kind of a normal cash mix that one might have in a wallet. Then we see this blue item that they had described. He describes it as the blue wallet from the coat that it had a lot of money inside, including the foreign currency. He did not know the value of the foreign currency. So this cloth thing, it's long. It's like about the shape of an envelope. It's blue. It appears to be like Asian. It's got a very Asian looking flower and a square on one side. It's kind of a quilted pattern to it. We then see a photo of what looks like it is both of these wallets and the money. And so I can clearly see like 4 pieces of currency on the left-hand side that are different colors. They are not US currency. It's, you know, currency from somewhere else, but I could not see, you know, what it was. And then what looks like it is supposed to be US currency. But again, you know, we have these screens, but I'm kind of far from them. Couldn't get like a real clear view of exactly what it was, but it's basically like several rows. So if that is supposed to be US currency, then it does look like a fair amount of cash. There's a photo that they took of Luigi at McDonald's that he identifies. He identifies the string, the change, the mask, that were taken from the beanie. There were some other items in this photo that he didn't recognize. I suspect they probably got them out of the backpack, but they were a watch, like a wristwatch, a Sharpie pen, and then some other item. I couldn't tell what it was. So Detwiler then confirms that he was the arresting officer, but the DAs were who decided what to charge. Specifically, he remembered having conversations with Nicole Smith about that. So then we see the criminal complaint from Pennsylvania, and we go through that. The address has been redacted, like they brought up at the beginning of court. So the first page has the case number and the judge's name on it, as well as Luigi's name and address. Pages 2 and 3 have the charges. They identify specifically the forgery charge. They read this through very quickly, so I did not get down each and every element, but roughly speaking, the forgery was with intent to defraud. He you know, had a falsified document. Charge of firearm that was carried without a license, that was based on it being concealed. It's a 3rd-degree felony. They established that open carry is legal in Pennsylvania, but concealed carry is not, apparently, without a license. A whole lot of issues there with the Bruin jurisprudence now, but that's an afterthought. That's not something to be really super concerned about at this point in time. They did not ever find a license, you know, for the firearm ever recovered. None was ever offered to them, so that was the basis for that charge. Next one, tampering with records. That was the identification based on falsifying a document to conceal one's identification. Possession of instruments of a crime, that's having things with the intent to use them criminally. Giving a false ID to law enforcement, and that was the misdemeanor, the after the warning by police giving false information. But it seems like he didn't actually do that, did he? So then page 4 was his report of essentially what happened at McDonald's. It is standard procedure in Pennsylvania to include that in the complaint. Page 5 had the signatures of the arresting officers, including him and also the magistrate judge. So now the prosecutor establishes the charges were lodged under Pennsylvania law. He was not charged with the New York charges. He does not have any knowledge of New York law as to arrest, search, seizure, frisk, questioning. He applied Pennsylvania laws through the course of all this. This is how we know that the state is going to argue this choice of law issue. They're going to try to say Pennsylvania law is what applies here. He testifies that the NYPD and Altoona were not working together. Well, but didn't he already testify that Hanley was on the phone with New York City getting information? And then we later heard this conversation with Fox, where Fox says that's the ID the shooter used to check into the hotel. So they got information from New York. So once again, this is a lie. This is a lie. Okay, at the very best, it's an exaggeration. It's being cute, real cute with your words, not working together to apprehend the shooter, perhaps, like Altoona isn't part of the ongoing investigation to find the New York City shooter. But for purposes of this arrest, were they working together? It seems pretty crystal clear that they were. He says they weren't. It's not credible. It's absolutely not credible. We saw it happening. Don't be trying to gaslight us over here. He reiterates he got his information from Fox News. He didn't get any information from the NYPD. Well, maybe he didn't personally, but clearly somebody got information about the ID that the shooter used to check into the hostel. He has made several hundred to 1,000 arrests before, so he clearly knows the policies and procedures. We now go through the search incident to arrest policy and procedure for the Altoona Police Department. He says it's consistent with Pennsylvania law. It's General Order 1.2. And it's we're going through the search incident to arrest policy. So it says that when arrested, a search may be made in accord with the following: a search of the person, clothing, bags, and packages that they may be in possession of. And also multiple searches are allowed as the individual is passed from officer to officer or facility to facility. So basically under their rules, each one of them gets to repeat the search. I did see this when I was doing a little bit of looking into kind of what the Pennsylvania standard is for a search incident to arrest. Their case law basically says if you were justified in going into this area at the time of the arrest, then even if you don't do it right then, if you wait until you get back at the station, it's still okay because you had the right to do it before. So the fact that you delayed doesn't really matter. And this just really emphasizes that distinction between the role that exigency plays in New York versus in Pennsylvania. Pennsylvania, it doesn't seem to matter at all because obviously by the time they have it back at the station in their property room or whatever, it's no longer a threat. They have total control of it and you're, over there cuffed to the wall by your ankle. But New York, that's still going to be a factor. So potentially a very important decision for the judge to make here, exactly which law is going to apply. As far as the nature of the crime, whether it's violent or non-violent, that doesn't matter in terms of their search policy. They search everyone who's being arrested, their person, their bags. He has, again, no knowledge of New York law. Before seeing Luigi on December the 9th, he had never seen him in person before. He doesn't know anyone from New York, and he has no connection to Brian Thompson. We took our afternoon recess at this point. Then we came back for cross-examination. So this was my first view of the the defense in action. Karen Agnifilo, Luigi Mangione's attorney, very experienced, former prosecutor. So I was really looking forward to kind of seeing, you know, what she brought, what her style was, and stuff like that. And I have to say, I'm sorry to say this, I have to say this, I was underwhelmed. I was underwhelmed. And I'll explain why as we go through it. You know, a lot of times just there are differences of strategy and approach and tactics, so to speak. And so it's not like you can say flat out, you know, something is wrong, because there's no like rule book about, I mean, other than like the rules of evidence, you know, there's no real rule book about like what's a good way to cross a witness or something like that. But you tend to learn what works and what doesn't work. And the problem was, as this cross went on, it became real clear it wasn't working, both in the standpoint of it wasn't generating the information that I think they were looking for, but also they lost the judge. They lost the judge. So let's talk about it. She starts by telling the witness that she was going to start where the state left off at the point of the arrest. So establishing, for the record, they did not get a search warrant. And Detwiler says that is not their practice when the search is a search incident to arrest. So then we go back to the body-worn camera at 10:03, which the state hadn't shown us before. And she asked if we hear something from Corporal Trent speaking in this portion of the body cam. And he said something like, at this point, I think we'll need a search warrant for it. That was that point that we heard about from the incident report where Wasser says, you know, she finds the magazine, spontaneously is like, oh, I'm just making sure there's no bomb in here. And then Trent says, I think we're going to need a search warrant for it. So the state objects to this and moves to strike because he says, hey, you know, I'm going to turn around what the defense was arguing before with the authenticity of this video. Detwiler wasn't present for this part of the video, so you can't ask him about that. But the court says, you know, you got to do plenty of that. I'm going to let it stand. So at least the judge is fairly even-handed. If one of the parties is going to, you know, take advantage of a standard, he's going to apply it against them as well. That's always a bit of a relief, you know, at least you have to fight a judge a lot of ways when you're on the defense. So it's nice when you don't at least have to, you know, fight for like the same rules to be applied to both sides. And the clarified then that when the person who is not the witness, when it's like video where Detwiler wasn't present, they're allowed to play it. They just can't ask questions about it because he doesn't know. So that's like the kind of standard that they stumbled upon one way or another. There was an objection in here that I didn't hear what exactly was said, but Karen Agnifilo, she has a little bit of a habit of, she's a little bit conversational in her cross, which I totally understand because I tend to be like that as well. But it means she adds like comments, kind of like she editorializes a little bit. She'll get an answer and she'll say like, oh, that's interesting. You're not really supposed to do that. But I you know, I have some sympathy for that because I understand it. It's part of like getting a flow. It's part of making it a little bit more conversational and having an interaction with the witness instead of just, you know, cold, remote, robotic type of questioning. But the prosecutor doesn't like it. The judge doesn't like it. So there was an objection here. It was sustained. She's told just ask questions. Don't make your comments. So then after the defendant was placed under arrest is when, you know, that had happened as far as getting you know, the comment about, oh, we probably ought to get a warrant here. That was after he had been put under arrest. We now go back to the complaint. We have the name of the attorney is Pete Weeks. Remember, he had said that he had spoken about the charges mostly with Nicole Smith, but it's Pete Weeks whose name is on the complaint. Forgery is listed as F2. That's a second-degree felony. The firearms charge is an F3. That's a third-degree felony. So forgery is a serious crime in Pennsylvania. The tampering with the records is a misdemeanor, and it says, knowing he has no privilege to do so, he falsifies any piece of identification with intent to deceive. And they clarify that that charge is relating to the fake ID. Then we go to the false identification to the law enforcement officer, and that is furnishing law enforcement false identification about false information about identification after being informed by the uniformed law enforcement officer that he is under official investigation. And so we established that the warnings had been for that, and he did not, in fact, give false information after that. Yes, exactly. Exactly. They charged him with something that they did not have probable cause for this crime. He did commit this crime. And like by their own explanation of why they give these warnings and how it works, they showed us he didn't commit this crime because after they gave him the warnings, he told them the truth. His name was Luigi Mangione. So he explains, well, he only charged that because I was told to charge him with that. I was told to charge him with that. I would have pushed on this a little bit because I was told is that passive voice. Always look for the passive voice on questioning and make them turn it active. Who told you that? Who told you that? Did you understand that you didn't have evidence to support this? Why, why did you disagree with that recommendation? You explained in your direct examination that if somebody gives correct information after this, that they're typically not arrested. And is it your understanding that's because it's not a crime? But you charged him with a crime here, and you signed your name to this under penalty of perjury. I would have really pushed on this because this is a great fact for the defense. That didn't happen. It just kind of got left there. I was told to charge him with that. So then we go to the text about the New York, if you catch the New York City shooter, I'll buy you a hoagie, and he texts back, I'll consider it done. And that took place over text, not the radio. So we already knew that happened. We didn't establishing anything new by just repeating that. The call had come in from dispatch as a suspicious male who resembled the New York City shooter. So it did not sound serious. That's why they didn't use the lights and sirens. We're now starting to get to a point where this cross is going to become extremely repetitive of what happened on direct. And frankly, it reminds me of the way prosecutors cross-examine witnesses. Prosecutors don't cross-examine a lot of witnesses. They are usually making the case. Often they'll go through a whole trial. The defense won't put on a case. The defense is basically trying to argue that you're not going to be able to meet your burden of proof. So they don't even have a defense case. So prosecutors often are not particularly good at cross-examination. And one of the ways you can tell is that what they do is they just go back over everything that was said on direct. And there's not necessarily a point. You're just repeating it. And it's not necessarily helpful to you to repeat it because it's not particularly good information. It came out from the other side. Like there's a reason why they put it on. Why are you just repeating it? So this was really my main criticism with the cross-examination here is that it was prosecutorial like that. It's just repeating what we already saw, what we already talked about. And part of the reason, there's two reasons why I think this is a particularly bad idea. One is because they really did have some gold to work with here. I mean, that example with the charging him when you didn't have a basis, that is freaking gold. Okay, that is gold. But you lose that when you bury it in this sea of information that isn't important, that's irrelevant. It's not helpful to your case. And the other thing that I really don't like about it is they bored the hell out of the judge. They lost the judge. I started watching him about maybe 45 minutes into this cross. I started paying real close attention to the judge because I want to see how he's reacting to this. And he was not pleased at all. I started to see him like looking around the courtroom. He starts resting the hand. He's making these facial expressions like the Peyton Manning meme, you know, that tight-lipped kind of face. At one point, he's up there like shuffling through papers. He's not paying attention even. You've lost him because he's already heard it all and he's not getting anything new from it. So, you know, again, this isn't a thing where you can point to a rule book and be like, that's wrong. That's not how to do cross. But you can definitely look at the effect of it and that it's you know, this isn't working. And what tends to work best in a cross-examination is to keep it short, keep it tight. You have very specific points you need to make. That's your gold. That's your gold that you have here. You go in and you make those points and you sit the hell down, right? Because then they're memorable. They've sat with the judge. You haven't got yourself into a situation where potentially you've asked too many questions. You've given them too many opportunities to now explain the same thing. So they've figured out how to fix a problem that there might have been, you know, when they explained it the first time around. It just tends to be a lot more powerful that way. So I was disappointed. I thought that this lost a lot of potential that it really had. So that was kind of unfortunate. So now we're revisiting kind of from the start, this whole process of the stop. Didn't use the lights and sirens, went to 407 East Plank Road at the McDonald's. He had the description. Fry was the rookie. He was doing the training. He's not a field training officer, but he was trying to help out some. So Detwiler drove, Fry operated the CAD. 9:27, they responded to the call. There's no audio for the first minute, but he had activated his body-worn camera. It's appropriate in his protocol to activate it for that type of contact. Took them about 10 minutes to get there. It was a big case, the shooting. He was familiar with it. He'd seen the photos, as he said, more than his own children. He did not pull up a photo in the car to refresh his recollection because he didn't have to. He had already seen those photos so many times. There was no plan or discussion about the strategy between him and Fry because they didn't think it was going to be him. They knew that a gun had been involved in the crime. It had not been recovered. They went for the reason of investigating the shooter, not because he had been there too long. At one point, I don't think I mentioned, in the conversation with Luigi, they tell him that the reason why they're responding is because McDonald's says that he had been there too long. And they'll get into some more detail with that in this other video. But that was not the case. They went there because of the call about him potentially being the shooter. So there are two doors that are on the same side of McDonald's, the main entrance on the left and the side area where he was on the right. The doors are about 20 feet apart or so. The main door opens, the one on the left opens to the main area where the food is ordered. The right door opens to this side back entrance. There's tables back there. They're calling it the side dining room, as well as two bathrooms and a utility closet. On the way back, they didn't stop and talk to anyone. And he says that's because Fry had identified him as being in the back. So nobody had like motioned to them. This is the guy. He didn't stop to ask anybody, who are we looking for? Didn't try to find the customer who, you know, thought he was suspicious or anything like that. They just walked in, go to the back. Fry says that's him. And the reason why they know is because, again, he's the only one there in the store with the mask on. So he I guess doesn't have the antibodies that they all have there in Altoona. They passed a couple of booths in the hallway down to the side dining area. Within about 2 seconds of the contact, they asked him to pull his mask down, and he did. And they know immediately he's the New York City shooter. He was the person that they were looking for. There was no doubt in my mind, Detwiler says, because he recognized him. She asked him about tactical positioning. Luigi, of course, was sitting with two walls on each side, a table on the front. The opening was over to the right. And so was his decision to strategically place one of you at the opening. The state objects at this point that she doesn't know, he doesn't know what Fry, he can't testify to what Fry was thinking or like what Fry's motivation was. So they're allowed to talk about where people were standing, not necessarily what they were thinking. So we confirmed, though, that he told Fry where to stand. Is it so he couldn't get away? Well, I don't know if it was so he couldn't get away. He doesn't know. He doesn't know that that's why. I mean, we can see for ourselves that's why. This is where, again, I might be a little bit nitpicky about the cross, because you have the facts to work with. You don't need to give him an opportunity to explain them or deny them. You have them for purposes of making your argument. This is the argument. This is asking about the conclusion to be drawn from the fact that somebody was always in that opening from the very beginning of the contact all the way in through the point that it was finished. And that would serve to put up an impediment to being able to just get up and walk away. So the conclusion is that this was strategically done. This was a tactical position, but the opposing witness is never going to give you that conclusion. They're always going to argue with you about that. So he did that in this case. No, he just denies. I mean, that's not, I don't know that I would say that it was so that he couldn't get away. I stood in front, and it's not like we're going to stand next to each other and hold each other's hands, he says. He's starting to get a little snarky. Like I said, with the defense, the hostility immediately starts to show. So he fights, he denies, he has his little quips, his little comebacks. It's a combative thing with the defense that it was not at all with the prosecution. Also very predictable, and it's again one of the reasons to be a little bit cautious with the cross-examination. Be a little strategic. His goal was to identify him first, and concedes he was not free to leave until I identified him. So that's clearly a factor to Miranda. He was not in fact free to leave. So if he had perceived he was not free to leave, that was correct. He was not going to be allowed to go until they got his identification. Now in Pennsylvania, that's legal. They can do, in fact, probably in New York as well, although I'm not as sure about that. But this is going into that Terry detention, where it's short. It's not associated with the kinds of restriction that a formal arrest is associated with. He wasn't in handcuffs or anything like that. He's not taken down to the station. It's a situation where we get him ID'd, and at least ostensibly he's going to be free to leave at that point. So now again, he specifically denies, I didn't strategically place myself anywhere. I just stood there. The challenge, with that is by using this as cross material instead of using this as part of your argument to the court, you've given the judge an out. If the judge doesn't want to make that finding, he can now point to it and say, nope, that's not what happened because the officer said it didn't happen. If you bring it up in your argument, he's gonna have to come up with the reasoning himself, and that tends to look a little bit more self-serving. It's a little bit harder to do. If he's like, well, you've pointed out they were positioned here, he can't leave, there's somebody always consistently there. If he has to make up some reason, like, well, just because they were all there doesn't mean, they were doing that on purpose to discourage him or anything like that. You're starting to look like a little motivated with your reasoning. So it's just a lot harder to pull off. Better to leave something like that in the argument. So now we go through Detwiler's entire body cam. We've already seen most of it. Remember, they're jumping back and forth between Detwiler and Fry. So we've already seen most of this, but we're now going to watch the entire thing from beginning to end. So we see it again. He walks right up to the side of Luigi, gets the name Mark Rosario, asks him, do you have your ID on you? He says he's allowed to ask for identification, generally are. He says he knew it was a person that NYPD was looking for. He gave the ID, handed it to Fry, stays standing over there to the right. He's from New Jersey. The ID is from New Jersey. He asked if you've been up to New York recently. He does not know the ID is fake at this point. So they are not investigating fake ID or forgery at this point. They are just trying to get him identified. He says, yes, sir, in response to that question about have you been up to New York recently? So then he asks again, what were you doing in New York? And he says that's because he wasn't sure what he said. I already knew what he was doing in New York, he says, but I just wanted to see how he reacted. She says, understandable. That gets stricken because that's a comment, right? That's part of that back and forth that I do sympathize with that a lot because I have a tendency to do that too. You react to what they say, and you're trying to make it natural and not so scripted and formulaic. But some judges are going to force you into that formula box. The judge says, "Well, I'm not going to strike it. Counsel gets the message by now." He says, talking now about your demeanor. You were just being friendly. Yeah, I was friendly. Well, but I wasn't friends with him. Well, no, we know you're not friends with him. But he says I was friendly. And she stops to kind of say, if I'm going too fast, pause me if you don't understand what I'm asking, because they have this, kind of back and forth about what do you mean about friendly? Like I was friendly, okay, well, but you weren't friends. No, we weren't friends. She's like, so if you don't understand, or if I go too fast or anything like that, feel free to stop and ask me to clarify. He says at this point, you're doing great. You're doing great. Well, how condescending is that? How condescending is that? You, the cop who can't even articulate your basis for it being a safety issue other than just saying over and over again, safety issue, safety issue. That's my magic word. You're going to tell this lawyer who's clearly quite intelligent up here that she's doing great. This was a real tell for the combativeness of it. This is how you know this is a battle that's going on, because he's trying to even the playing field from a power standpoint. He's trying to regain the upper hand, regain the position, dunk on her, basically. He's trying to dunk on her to get some type of leverage there in the courtroom. So he reiterates that he's just trying to see Luigi's reaction when he's asking him about being in New York. So then asks him 3 times, stand up, put your hands on top of your head. 3 times he asks him, put your hands on top of your head, put your hands on top of your head. You seem a little nervous. Why are you nervous? Why did you ask him 3 times? Well, he wasn't putting his hands on his head the first 2 times. He patted him down to make sure he had no weapons. He was not looking for or did not find any other evidence, and that's why he didn't find the peanut butter. He didn't feel any weapons. He was mostly worried about a gun. He was 100% sure that he was the male they were looking for. He's now, at this time, he's in full uniform, the same as what he was wearing currently on the stand. He's got his shield displayed. He's got his service revolver. Fry is also in full uniform. This is going to the circumstances, the intimidation factor. Is he going to feel free to leave? These aren't like plainclothes, casual guys. These are fully uniformed police officers. This is sometimes there's a little bit of a double-edged sword in these types of motions. There's a little bit of one with standing that if I have time here and I don't lose my voice too quickly, we might get into. But this uniformed one is potentially one as well, because if you remember back when we were reading through the probable cause statement about the basis to the elements of the charge of the false information to a police officer, it was after, being informed that you're under official police investigation by a uniformed police officer. The police officer being in uniform is an element of that crime. And so there has to be some evidence, to give you probable cause to think that's the case. The state never elicited that he was in uniform at the time. And this is like one of these things that is super easy to overlook. I actually had a case on appeal that I won where it's a very similar issue, the eluding statute in Washington, attempting to elude a police officer. requires all these different technical requirements that the officer is in uniform, he's in a marked police car, it's equipped with lights and sirens, so on and so forth. And just like this, they went through the entire trial and never elicited the police officer is in a uniform. So they had insufficient evidence of one of the essential elements of the charge. Very, very crystal clear. One of these things that like they practically gave you a script here for what you need to establish, because here's the elements of the charge, just ask all of these things, but they didn't do it. So let's go to a counterfactual here where that evidence never comes in court because she never asked this question about him being in uniform. We now have another argument, another potential argument that this basis for the arrest, it's no good. Like, to the extent you are arresting him on this charge and searching him incident to that arrest, that is not a good arrest. He didn't give false information after being warned, but also there's no record that you were in uniform at the time. Now that's a weak one here because we got the body cam. And we can see, you know, he's wearing some kind of uniform, and that's probably going to be enough to get him over the probable cause hurdle. So in terms of the trade-offs, this one, you know, minor, probably well worth it in terms of establishing just the, you know, the nature of the circumstances and the intimidation factor and so forth. But it might be a little different when it comes to standing. I'm just going to go ahead and go off on the sideline for a minute here because now it's on my mind and I don't want to forget. Standing goes to your ability to be able to move to suppress evidence in the first place. And the idea is that everybody has Fourth Amendment rights to privacy in their persons, their effects, their papers, all their home, all that type of thing. And so you get to challenge police intrusions on your privacy interests. You do not get to challenge police intrusions on other people's privacy interests. So if the police, for example, break into your parents' home and you have stashed evidence of a crime in your parents' home, you don't live there, you know, you haven't lived there in forever, you're not a guest there, you just like took something there to hide it. Police break into their house without a warrant and find it. You do not have standing to challenge that search because you don't have an expectation of privacy in their house. It's their house. They're the ones with the expectation of privacy. So it's one of the kind of foundational requirements that you have to show to be able to establish that you're entitled to evidence being suppressed. It's fairly easy in the context of something like a home, a piece of property, you know, what's your right to be there? It can be a little bit harder with things like personal property because, as they say, possession is 9/10 of the law. But there's all kinds of different ways, even with personal property, you know, I had it, maybe did I abandon it? Did I abandon an interest in it? Like if I tossed it, you know, police are chasing me, I tossed something, you know, to try to get it off me. Have I abandoned my interest in that piece of property? Most cases will say yes, you have. I borrowed something from somebody. It's not necessarily mine, but I'm keeping it for them. Somebody else lost something and I picked it up. Like there's all these different ways where the interest in that particular piece of property can, you know, get a little bit complicated fairly quickly. So the way that that plays in this particular motion has to do with the backpack and his contents. Luigi's going to have to establish his interest in those items, and potentially not just the backpack itself, but the things within the backpack to the extent that police unlawfully searched those as well. So things like this wallet, you know, the wallet was on his person, but the wallet that they opened up, for example, the contents of that wallet, got to establish you have some standing, some privacy interest in that wallet to complain about, you know, what they found inside it. Where I think this is potentially an issue with the backpack and the contents of the backpack is the notebooks, because going in and opening up and reading the notebooks that's going to be hard to justify under either the search incident to arrest, you know, exigency grounds. There's nothing exigent that requires you to read something. You just need to recognize it's a notebook. It's not a weapon. Same thing with the inventory search that they're likely to use to try to justify the backpack search back at the station. We had to keep his property. We don't want to be sued if something gets lost. So it's customary when somebody's arrested to see everything that they have, write it down, have a record of it, and then there's no dispute when they get it back that, you know, maybe something that they had at the time they didn't get back. But reading the notebooks, again, is not necessary to inventory that there was a notebook here. It was a, you know, 200-page blue-colored, you know, ring binder notebook, whatever it was, whatever the description is. You don't need to read it. So the reading of the notebook and the contents, to me, is potentially problematic as its own search within a search, because they had to open up the notebook and read through the contents of it. So that creates now potentially this double-edged sword. Because if you have standing to challenge the search, you have to be claiming some type of privacy interest in these items. It doesn't necessarily strictly mean like it has to be mine, I have to claim it. But it's got to be more than possession, at least under New York law. It can't just be I had it in my possession. You have to establish like I had it in my possession and I had a right to keep it private from other people. So it's getting fairly close to like, you know, it was mine. Double-edged sword of that, you know, it was mine, to be able to move to suppression, but it was mine is not really good from an evidentiary standpoint. If that's like an admission that they can use against you at trial, hey, you said it was yours for purposes of standing, then it's going to be hard to deny that that, you know, the contents are attributable to you. Not impossible, but just, you know, puts it in a more difficult situation. Another reason why it's potentially a problem is because if the court ultimately doesn't buy your justifications for suppression, your arguments on the lack of a warrant, then you've handed them potentially, you know, more ammunition for the search incident to arrest exception. Because remember, the search incident to arrest is to you and the items in your immediate possession. If you're saying it was in my possession, you're kind of almost giving them, you know, a big piece of that. So that one is much more of a double-edged sword, much more of a strategic decision kind of area, where it can be very significant, you know, where you decide to go with it. Ultimately, you know, because they're going forward with this motion, and this motion is so extremely important to the outcome in the case, I think, you know, if push comes to shove, they're going to have to establish, yeah, he had some kind of privacy interest in the backpack and all the contents of the backpack. And that's difficult because, you know, Luigi's already on record as like wanting to distance himself, disclaim ownership of some of the contents that were found. You know, I know the cash in particular says it wasn't his, didn't belong to him. I know that Karen has made statements before about he does not subscribe to the writings. They're not his thoughts, they're not his beliefs. So he seems to want to, you know, distance himself from those as well. And, you know, from a defense standpoint at trial, strategically, I certainly understand that, because the notebooks are not real good. You know, they lay out the planning, they lay out the selection of the target, they lay out the motive and the thought process and so forth. So they're very incriminating. But if you don't claim them from a privacy, you know, perspective, then you're not going to be able to move to suppress. So very difficult situation for them to be in. Go back to my notes. Where was I? Oh, the uniform. Yeah, the uniform that really isn't going to matter for purposes of this motion, but led me to that that trade-off kind of discussion that got us into standing. So he establishes he was in control of the entire McDonald's at this time. He felt like he was in control of the situation. He wasn't worried. He was calm. He does not remember unzipping anything during the pat down. They thought they heard a zipper on the video, but he says he doesn't remember unzipping anything during the pat down. When he went outside, he told Fry to go stand where he was. Then you see him on the camera. The wall appears to be curved, but that is just a camera distortion because this is a very wide angle lens. So it distorts the straight wall into, looks like a curve. You hear the phone call, Tom, it's him, he's here. He explains Tom is Lieutenant Hanley, asked him if he'd been up in New York recently. Why don't you come out here? He comes back in and Fry is standing to the defendant's right. He is leaning now kind of on the chair that is in between him and the defendant. He came here from New Jersey. He says, yeah. He reads the number to dispatch. Asks family down here. No, I'm homeless. Been up in New York lately or not? He says, no. And so she says now this is the third time. He says it's the second time. I agree with her count. This is the third time. He asked him twice before. First time, Luigi said yes. Second time, there was no answer. This is now a third time, and now Luigi says no. He says, I'm trying to confirm your name. We'll get out of here, once we get that done. That was not true, that they were just waiting for ID. He was, in fact, waiting for backup. He asked Luigi, how long have you been here? Luigi said about 40 minutes. Nobody, in fact, had said from McDonald's had said that he had been there for a while. He explains to Luigi, they have a policy here that if you stay too long, they call us. That's a lie. He's not sure if they actually have a policy like that or not. What brought you here from New Jersey? He says, I haven't been to Jersey for a little bit. Ask where he's from. He's from DMV, and they clarify that's Delaware, Maryland, Virginia area. He's from the DMV. And Detwiler says they're just making small talk until the backup arrived. Again, the situation is under control. But he did fear that there was a firearm. There could be a firearm in the bag. And she says, but you didn't move it. You didn't move it, though. And he says, well, not yet. Well, this is another really good fact. You're trying to justify getting into this bag and what you did, how you handled this situation based on your safety concerns. But you stood there and let him be right next to this bag that you're saying you're worried had a firearm in it for like 10 minutes, 10, 15 minutes. You don't do anything with it. So that was, I thought, a really good point that got a little bit lost in this revisiting of everything. Why wouldn't you have moved the bag? Wouldn't you have moved the bag right away if you were scared? He says, I don't know. Well, that means you don't have an answer. You didn't have a script for this one. You didn't anticipate this question. So Luigi then on the video is pointing to his receipt, and the receipt shows, his purchase was at $8.55. So he really had not been there, for very long. They had his ID still at this point. One of the things that Karen is getting at, you have his ID. So, person can't just get up and leave their ID. Like, you are controlling the length of the contact by not giving him his ID back. But he says at this point, he was starting to think it was fake, and he had it the whole time while he was running checks on it. At one point, he has it clipped to his uniform. He does not remember if there is a CVS bag on the table. We spend some time looking over the body cam, kind of going back and forth to see if we can see the CVS bag on the table. The laptop as well. Where's the laptop? He's, well, I'm not sure where it is right here. I thought it was on the table when we came in, but now we're looking at the table. We haven't seen it on the table yet. And he's like, well, I thought it was there. I thought there was a laptop there. This is also a good point. I mean, I don't know how critical it is for purposes of this arrest, but potentially for a search in terms of what was in his immediate possession at the time of the contact. If the laptop wasn't there out on the computer, then or wasn't out there on the table, then you might not have as good an argument that it was in his immediate possession. But either way, you know, again, goes to credibility. You said he was on a laptop when he came in. We haven't seen a laptop at any point in any of this video. And now at this point, we're like prime. So we're looking, we're looking at all the body cam, trying to see where is this laptop? Never saw it. So at 9:37, he gets a call on his cell phone from Wasser. He says, I'm a little busy. I'll call you back. And then like hangs up. That's it. So he does not tell her to come down. She ends up coming down anyway. So it's been about 10 minutes. He hasn't moved the back yet. Fry is to the right of him. One of them is standing there the entire time until backup gets there. They have a little conversation about what he's eating. Are you eating the steak? Is the steak your, he says the steak's, you know, steak's my favorite. And Luigi's like, yeah. And so she asks, is the steak your favorite or is that another lie? And he says, that is true. That part was true. The steak really is his favorite. So now we see the CVS bag on the table. We're listening to Jingle Bell Rock in the background. They're still just having the chit chat. He starts whistling now with the music, whistling along with it. It's really loud. It comes through really loud on the court audio, and I think the bailiff might have thought it was somebody on the courtroom. He might have not realized that it was the audio because he yells, "Quiet down." Everybody's like, what? Who did what? I didn't hear anybody saying anything. I just hear this really loud whistling start to come out over the audio. And the bailiff yells. I think he got jump scared. Maybe a little trigger happy dude. Maybe chill just a little bit. You see Luigi has his back to the corner of the room. So now at this point, Hanley has walked up, taken the ID. They didn't have any conversation. They didn't need to because they had that previous phone call. Now he moves the bag and it's 9:41:11. So he's now been in the McDonald's for a little bit over 10 minutes, like 12, 13 minutes. He puts it behind him to the defendant's right. So now they are both him and Fry at the side of the table. The chair is out in front. Now Burns arrives, Sergeant Burns. We go through the hierarchy of who is present. It goes the patrolmen are the lowest, to the corporal, to the sergeant, to the lieutenant. They also have separate divisions. They have the CID, which is the investigations division, the patrol and their narcotics divisions. There's somebody from like each one of these at some point in this whole process. We go back through the hand motion the narcotics guy was making. That was about patting him down. He said yes. He tells McCoy to stand over here by him while he goes outside. And his explanation was not to block his exit, but mainly to stand by the bag and make sure that the defendant couldn't get to the bag. Reiterates he's 100% sure it's him. He's seen all the pictures. Tells the guy he's nervous as hell. He got quiet. So this is that conversation they're having outside. And then again, seeing them like looking up the New York City shooter photos, saying there's better ones. It's raining outside. Just observing that for some reason, I'm not sure. So then we move to a different video. This video ends. And so he explains that the reason these are different videos and not continuous videos is because he stopped the videos at some point during his conversations with these officers. So now we have some occasions where he's muted it. And we also have occasions where he just turned it off and then turned it back on. So this, I think, is a good and important fact as well. Good to elicit that. So he says we were going to talk about how to do something or what we were going to do. He doesn't want the conversation heard, acknowledges he intentionally turned it off. He doesn't explain and isn't really pressed on, well, why did you mute it sometimes versus turning it off? Like, is this part of the policy? You didn't do these explanations. Remember, I talked about, this policy says you're supposed to announce, what your justification is if it's reasonable. You chose not to do that. You didn't comply with your policy. Why didn't you think your policy needed to be followed? Especially given like the scope of what you think it is that you're doing here. You think you're investigating this shooter, this high profile person from this incident that's been all over Fox News, that you've been watching for a week so much that you've seen his pictures more than your own kids, and yet you didn't think to follow your own policy. Like, of all times when you should be so completely by the book, did you not think maybe this one would be that? Don't know. So the first video ended at 9:43:42. The second one starts up at 9:45:36. So we know it's been off for about 2 minutes. There's, at this point now, when they go back in, about 8 officers there. The backpack is on the table over to the left. We still haven't seen who took it from the floor and put it on the table. We identify in this scene Fox, Nowler, Yeager, Fry, and McCoy, all in the frame. The chair is in the same place. The backpack is off to the left. Asked about the distance, like the relative distances between things here. Asked if he would be surprised if the distance from the one wall to the other wall is 13 feet. He says that's about right. She does some math, and she does a good job here of like walking him into the conclusion that she wants him to make by kind of forcing him to do the math. So she gets him to concede, like, we're all using our own eyeballs here looking at this video, right? So you'd agree that, okay, it's 13 feet from wall to wall. You've agreed with that. The backpack is maybe 2 to 3 feet from the wall over on the left-hand side. Yes, he agrees with that. And Luigi is back there in the corner. He's like on the other wall. So that means the distance would have to be 10 feet from the backpack, right? Yeah, it does. That's the math. That did a good job. So remember, before he was like really minimizing the distance between them. No, at this point he's about 10 feet from that backpack. So now the camera is muted. We just see Fox smiling, but we don't know what's being said. There's multiple officers around him. They're in the hallway. They're by the side exit. They give him the warnings about the police investigation. They ask for his real name. There's a fairly noticeable delay in answering, like he doesn't snap answer. It's more like, what's your real name? Luigi Mangione. Gives the birth date. There is some confusion about how it is spelled. Apparently, when they first ran it back to dispatch, they spelled it incorrectly. So she clarifies that is not from him. He spells it out for them, Mangione. He does it correctly. The issue had been with whoever wrote it down. I guess either wrote it down wrong or had terrible handwriting. So when they read it back, they actually read it back to him, and he had given it to them correctly. So he did not give them false information about his name with that either. If they were going to try to go with that, he gave it correctly. So then Foss asks why lie about the name. Go into the middle name of the middle initial N, Nicholas. There's about 10 cops there now. Confirming you gave us a fake ID. He says yes. Someone at this point says Mirandize him. He identifies that as Trent. So then his rights are read to him. During this whole incident, we're seeing customers go in and out of the bathroom. That's like right there. Remember, Luigi's in the corner, and the corner like is one of the bathrooms. I don't remember if it's the men's or the women's, but it's one of the bathrooms. And so people are like walking right past this area and going inside into the bathroom, coming back out. She confirms they weren't worried about these people coming in and out of the scene because they had the whole situation under control. She's emphasizing the show of force and the dominance. When you have this many police officers in this one area, they don't really have to be that concerned about like what is some random guy going to do with his backpack. Like, you got 10 cops there. You're letting people go in and out of the back bathroom. You're not worried about any kind of interference. We then see Fox patting him down again. His hands are on the wall, so we're just observing. He's got a little different way of doing the frisk. You had him put the hands on the head. Fox has him put the hands on the wall. Different frisk. There's a pocket knife now. He identifies a pocket in pocket knife. Luigi says, there's, a knife, pocket knife in my pocket. They ask if you mind if I reach in and get it. We see him starting to put the gloves on. We see Fox handcuffing the defendant. Hanley and Trent at this point, we reiterate, had been talking to NYPD about the incident and about having him here. So you were coordinating with New York about this actual arrest. Also, the DA's office, they were talking to the DA about the charges. He says, I don't know what was discussed, just that they were trying to get contact with the NYPD and the FBI about the shooting. And he believes that this was going on, but he doesn't know the details about what was said. Well, we certainly know that somebody told him this is the ID the shooter used to check into the hostel, because they did not already know that, and that was not public information. She elicits that the Pennsylvania Attorney General, I think his name is Andy Chris, was there. So they have an AG there. And maybe he was involved with contacting the FBI. Maybe. Not entirely sure. But he is the one who took the photo of Luigi there in the restaurant. He used to be a police officer, but he is now an AG. He reiterates that he pushed the backpack, pushed it back, pushed it out of the way. We already know that happened. So at this point, there are now 3 officers that are standing between Luigi and the backpack, and he is handcuffed. So we're emphasizing the facts that show not a risk that he is going to get into that backpack under these circumstances. He was not ever given back his New Jersey fake ID. This is going to the argument that he was never going to be free to leave. He was, essentially under arrest from the time they walked in. Fox said it's 100% him. I said, I told you so. You hear this conversation happening, then it mutes again. At this point, this is when I start to notice that the judge is gone, right? The judge is gone. The judge is like looking all over. He's not looking at the screen. He's not really paying attention. He's kind of looking like he's trying to stay awake. I have some sympathy for this too. I myself get that mid-afternoon, like post-lunch lull, where it's like the digestion, all the blood goes to your stomach and like you just want a nap, at 3 p.m., like prime nap time. It's getting to be that time. And the judge is fighting because, again, he's heard almost all of this already. And they have not, done the work of like sorting out, selecting out what are the pieces here that are really important versus what is just repeating to me what I've already heard and don't need to hear again. So it's 9:56:10. We see Wasser he's standing next to Wasser and they're having a conversation and she says, wow. And then her eyes look down towards his chest, like in the area of his body camera. And then the body camera gets turned off again. You don't say. Almost like she like signaled. Wow. And he turns it off. No explanation why. Didn't hammer on that. Just established that it happened. But no, like, so what were you talking about here? Why would you be talking to Wasser about, like, what are you going to do? She's a, low-ranking person. You're a low-ranking person. You don't have any call about what's going to happen. Hanley's on scene. He's going to be calling the shots. Why would you be having administrative conversations with Wasser? I don't know. So this one, he stops it at 9:56:10, then it comes back on at 9:57:12. So once again, about a minute he chose to not have that camera running, and we have no idea what's happening during this time period. There's a little short period where you can't see anything because he's leaning up against this railing, and so it's blocking the camera. But then we see them approaching Luigi and making the arrest, McCoy picking up the McDonald's, the trash. She asked if they had no reason to take papers from the food that the defendant was eating. Remember later on they get the pizza and the drink from his jail cell, and the reason they're doing that is to get DNA, right? They're doing it to pilfer DNA in case they needed that for some type of comparative sample. That's what she's getting at. You could have just used these McDonald's wrappers, maybe. And he's like, I didn't even think about that. Didn't even think about them having any kind of evidentiary value. All these freaking cops on scene, including detectives, and not a single one thought, hey, you know what? Maybe we could get some DNA off of these and it might be helpful. That may turn out to be a extremely unfortunate oversight for them, you know, if the rest of this stuff ends up going down the tubes, because, you know, the McDonald's was trash. The McDonald's is arguably abandoned, no expectation of privacy in it. If you had gotten his DNA from the McDonald's bag and then compared it to all the stuff that they got from the scene of the shooting, potentially untainted. And so now your prosecution maybe is still going to be able to go forward even if this motion to suppress is granted. But they didn't do that. They didn't do that. 10 or more cops on scene, including detectives and the high-ranking guys, and not a single one thinks, oh, maybe his DNA would be on that wrapper and maybe that would be a helpful thing to collect. Nope, they just threw it away. Didn't occur to anybody. So at 10 o'clock and 47 seconds is when they're taking him out of McDonald's. He is one of the arresting officers. He explains he had to leave for a family thing this day, so he was the co-affiant on the warrant. There were the two of them on the complaint. And so Fry stuck around for what he called the circus. Fry stuck around for the circus, and I went home. And then he clarifies the circus is, you know, the media stuff. But they were the ones who found Luigi, so they are the ones who were, you know, formally the arresting officers. He was honored by the NYPD for this arrest. They made him an honorary officer. He got an award for it. He was proud of it. You know, she's getting into kind of his maybe personal interest, maybe bias in, you know, you wanted to be the guy that arrested the shooter. You got all these attaboys for it. Yes, you were proud of it. He was proud of it. He thought he was doing a good job, but to him, it was just another arrest. Well, that's bullshit. We know that's bullshit. You were totally psyched that it was you. And apparently the award was posted on social media. Photograph of him getting this award in New York. He says, I didn't, my wife did. His wife did. His wife posted the photo. We go back to the camera, see them putting him in the car, Luigi in the car. There's nobody in the back with him. Another officer came out of the McDonald's with them, helped them get him in the car, but did not come with them. They then headed to the precinct. Once again, no lights and sirens. They just drove normally. I have some notes here of the judge, like, you know, judge is watching, judge is looking, judge makes like a small yawn. Judge is done. The judge, you know, the judge reminds me, I can't remember what that guy, he's like one of the morning show guys, Harry something, Harry, a little bit of that. Also maybe like a Captain Picard with glasses. Like that's kind of his look. He's got this sort of stern, he's another bald guy. Kind of stern looking, got his glasses. So he doesn't make a lot of faces, and that's why, like, when he is doing this, like, you know, pulling his lips and yawning and stuff like that, it's kind of really noticeable because his default is very stoic. So you're seeing these reactions that to me are very clearly signaling like he is not paying attention anymore. This has gone on too long and it's too repetitive. We see them give their names, Detwiler and Fry. So he, you know, Luigi had asked them for their names. We know that. He doesn't remember. Luigi said something from the back seat, but we hear, I think, Fry say the fake name was ridiculous. The fake name was ridiculous. They called dispatch, told them that they were en route to the station. Now is the point where the judge is flipping through papers on the stand. At 10:23, they arrive at the precinct. It's about a 9-minute drive. Luigi was cooperative. He did not fight. He didn't struggle. They parked some distance from the door. They walked across the entire lot. And then his camera goes off when they get inside, and he says it's because the deputy chief was calling him in to talk, and he did not turn it on again after that. He left that day after the complaint was done with Fry, and that was around 3 p.m. So he spent from about 10 to 3 in the report room working on the complaint. Said he also was going up to the roll call room where everyone was at to ask about the evidence that they found. So this was an ongoing process, right? We already know that because we know that the complaint contains charges arising from evidence that they found during the search, specifically the firearm. So, you know, five hours to write this, to fill out this form. You know, the 7-page form is you know, there's probably a lot of cop jokes that you could make about that, and they're probably not untrue either. But some part of it is also because they're still waiting to see how things unfold before, you know, they make these final decisions about what the actual charges are going to be and so forth. Didn't follow up with that. You know, who told you to charge this charge you didn't have probable cause for? How did that all come about? He says he mainly spoke to Hanley and to ADA Smith. He did not draft the incident report that day. He did that the next day. He does not remember if he reviewed the body-worn camera to write his report. Might have talked to some of the other officers to refresh his recollection. As far as before his testimony, he met with the New York DAs before coming here 4, 5, 6 times tops. That's kind of a lot. It's kind of a lot of prep, honestly. Like 4, 5, 6 times in preparation for trial would be a lot, you know, but in preparation for a suppression hearing, to me, that is definitely a lot. Like, they have gone over what his testimony is. And even if nobody has told him, here's what you're supposed to say or so forth, they've made it real clear what questions are going to be asked. And I would imagine that they have sort of rehearsed to enough of an ability to be able to maybe express displeasure if he answers in a way that they don't like, and suggest maybe he might find another way to answer that. Not going to put words in his mouth. That would be unethical. That would be coaching. But letting him know, you know, you could maybe come up with a better answer for that. Hint, hint. That's what 4 to 5 to 6 prep sessions sounds like to me. That's a lot. So they met in both Pennsylvania and New York. They did not meet. He did not meet with the U.S. Attorney's Office. He might have talked to the FBI that day upstairs in roll call, but he does not remember. And that was the conclusion of the cross-examination. Now, I was critical of it, you know, in many ways, mostly for the repetitiveness. But I also have to appreciate and give some leeway for the fact that one of the reasons why pretrial hearings like this are so valuable for the defense is because this is like a free shot at the state's witness, at one of the very important witnesses, the arresting officer. Not just to be able to get information that you don't already have, get him to clarify things that are absent from his report, but also to just get a feel for how he is as a witness, and that'll help you strategize a lot better when it's time to go to trial, if the case makes it to that point. So that's where I think she's going at the end here. You know, she didn't know, like, where does the FBI come into this? How is the FBI interfacing with the local law enforcement? Did they interface with Altoona or just with NYPD? Because all these things are going to potentially matter, not just in terms of them being able to build up their timeline and their, information handling, right? Because one of the things that happens in a real big investigation is the telephone game. This cop talks to this cop, who talks to this cop, who talks to this cop, who writes the report. But by the time he's written the report, it's nowhere near, the original information that was provided. So it could be some of that. It could also be relating potentially to this issue of how much communication was Pennsylvania having with New York in the course of making this arrest. Because if the shooter investigation is like playing a role in what they're doing here in Pennsylvania, then that makes it much greater likelihood that the New York legal standards for the arrest and the shooting are going to be applied by a New York court to what is happening over here in Pennsylvania. Then we had redirect. Redirect about those DA discussions. Nobody suggested what your testimony should be, right? Absolutely not. I put that one in quotes just because. Absolutely not. No, emphatically. Nobody said what I should say. Maybe they said what I shouldn't say because we didn't ask that. At the time that the defendant was handcuffed, he was detained, according to Detwiler. He was not ankle cuffed at that time. He could kick, he could shove, he was standing, so emphasizing both. He wasn't under formal arrest, so no Miranda requirement, and he was still in a position where he could pose a risk to the officers. He could maybe get free, he could maybe cause some kind of damage. It was the defendant that chose the location in the McDonald's. That had nothing to do with, they had nothing to do with where he chose to sit or what the wall configurations were. Recognizing him from Fox News did not give him the authority to arrest him for murder. So that's correct. I mean, definitely, absolutely not. But this is going to the arrest versus detention. What exactly are you doing here? You're not taking him into custody for being the shooter. You're just detaining him for investigative purposes. But I'm not sure that's super helpful for the prosecution because, yeah, what exactly are you investigating him for? It's a pretext. We know that this is a pretext. Now, in and of itself, that's not constitutionally problematic, although, in my view, it should be. But for the most part, the case law says it's not. But it doesn't help your credibility, especially if you're going to be trying to sell this to a jury. What you're doing, you're just no, just trying to check his ID. Well, why? We all know this is about the shooter, and we all know that if this is the shooter, you are not going to just let him get up and walk away. That's one of the big counterfactual situations here that I kind of keep coming back to. If Luigi had not given them the Mark Rosario name and ID, and he just told them he was Luigi Mangione, and they run his name, and he's Luigi Mangione, and he has no warrants, and he doesn't talk to him, they got nothing. They got nothing. I'm sorry, but some guy thinking, oh, I recognize those eyebrows. No, that is not going to give you a basis to arrest. But they would have used every trick in the book to try to get something. We know that because he's pretty much told us as soon as he said I was 100% sure it was him. Well, then you're not letting him go. You're not letting him walk out. You're gonna find something. We know that. But I still think about that counterfactual. If you hadn't given them the ID, they don't have a basis for arrest. And if they don't have a basis for arrest, so what? He's Luigi Mangione. That means nothing. That means nothing. If he doesn't have warrants out for him. I guess they would find, his parents had made a missing persons report. Maybe that, but they didn't mention that coming up in the NCIC. So I don't even know. That's really not the type of thing that typically comes up in an NCIC. So yeah, could have been a very different story here. That Mark Rosario, that was a big mistake. That was a big mistake. So he did not communicate to Luigi that he was not free to leave. Told him that it was just about him staying in McDonald's for too long. Luigi asked what could he do next time, to not get hassled by the police if he's going to be in McDonald's for a while, I guess. Go back through the hierarchy of who's there. We have Miller is the corporal who's present. Burns is there. He's higher authority than him. Hanley is the highest one on the rank of everyone that's there. The false ID warnings tell him that you're under official police investigation, and if you give a false name again, you'll be arrested. And after the warnings, Fox asked, "Why did you lie?" This isn't helpful to the prosecution, so I'm not sure why they re-elicited that, because this is just kind of re-emphasizing, number one, you didn't have probable cause to arrest him for this, even though you put it in your complaint, because he did not lie to you after that. And you're now emphasizing the timing, that you asked him the incriminating questions after, after you had, some suspicion. You had the reasonable suspicion that he'd given you the fake name, and that's going to increase the probability that they're going to find this a custodial situation. They're already planning to arrest you because you've already given them something that they can work with. His wife is proud of the work he did, and that's not a crime in the state of Pennsylvania. Oh, what a like pointless thing, but I don't know. Prosecutor wants to get that swipe back, I guess. Come out on top on that one. It's not a crime for your wife to be proud of you in Pennsylvania. Just a crime to have antibodies in New York, I guess. We had a brief recross where they reiterate the police had nothing to do with where Luigi was seated, but at the time that he was handcuffed, he was 3 feet from the bag, and officers placed him there because he had been seated. They stood him up, and then Detwiler comes around, like moves him so that he can come around to the side. So they cuffed him in the area where he was first found, but then they moved him over to the walkway between the two tables, got him closer to the bag. And so this is being brought up for a couple reasons. One, again, undermines your safety argument here. Okay, if the bag is so threatening to you, you're getting him closer to it. But also, if how close he is to it is one of the factors that the court looks at to decide, is this an exigent circumstance under the New York standard? Is it in a quote unquote grabbable distance? You put him there. He wasn't already there. That was something that you did. Okay, it wasn't in that position at the time that you arrested him. You just moved him there in the course of taking him into custody. Then on redirect, he acknowledged that Luigi was in custody. He was under arrest in custody at the time that he was that they moved him. So that was the substance of the hearing. That was what we got. But then we got a little drama. We got a little drama with court transparency. Why is there always court transparency drama? Why do we not just get to see what is happening in our courts? Why do they have to act so imperial? Like, we don't have the right to know what is being done in the name of justice in our names, in our institutions. I don't know. I really don't, but it's just become so common. I guess I should start to expect it now. So at the close of the hearing, the judge says, I understand the defense has an application. And so they do. One of the junior defense attorneys stands up. He's got a scripted presentation. He says that several body-worn cameras have been submitted and that the defense has no objection to the videos being played in open court in front of the media, but he does object to copies being provided to the press. He believes there is prejudice to a fair trial if because it shows statements that may ultimately be suppressed, the statements that are the subject of the motions. He cites to a case, Daily News versus Wiley, where it says the court can control the records of its own proceedings, and it has the inherent power to do that, and it should balance the interests of the public and the defendant in the right to a fair trial. In Wiley, the issue was the defendant's videotaped confession that was itself, again, the subject of a suppression motion. The court in that case agreed to play it in court but not give copies to the press. So the defense is asking the judge to follow that same ruling in Wiley. So then the state says, basically, we're not taking a position on it. We think it's up to the discretion of the court. We, you know, the entirety of the footage has been played. It's all in court. So at this point, the court is starting to rule on the motion. He's saying that there's a number of exhibits that have been introduced. The press is present. At this point, there is a couple of people. There are a couple of people that are standing up in the press section, and the bailiff yells at them, "Sit down, sit down." Now, the bailiffs have been kind of yelling at people throughout this whole process, you know, sit down, don't talk, you know, just like when the whistling came on and they, you know, thought it was the audience, quiet in there, you know. So I just kind of assumed maybe somebody is like getting up, getting ready to leave early, putting their, you know, stuff in their bags, whatever, and the bailiff's just yelling at them, you know, sit down. But so I look and the lady, you know, sits down like very slowly, very reluctantly, and the judge is continuing, and the lady speaks up and she says, "Your Honor," and the bailiff now yells again, "There's no audience participation here," and you know, no talking. You're gonna need to leave. They boot her out of the courtroom. Tell her, you know, take all your stuff. And so she's mumbling on the way out the door. I'll call my lawyer. And then they yell at her, "You do that. You call your lawyer." Like kind of wild. All this just unfolding right in front of the judge, right? So then he goes on and announces his ruling. Well, my job is to balance the rights, and since this is a suppression hearing and the court hasn't ruled, sealing would prevent. He finds that sealing would prevent a substantial probability of prejudice to the defendant's right to a fair trial in the event the evidence is suppressed. And so he is going to seal every exhibit at this motion until the trial is started. And at that point, the press can move it to have it unsealed. And then, bye guys, see you Thursday at 9:30. And that was that. So what was up with that? What was up with that? This is an issue, and it may not be like the biggest issue in the world, but this is a major First Amendment issue. Okay, access to courts, access to court records. These are issues in which the public has a First Amendment right of access. And so, very clear to me what is going on here. Defense wants to, you know, close off the ability to be able to show the body cams that we all saw in court to the public. And you know, defense doesn't want them to be able to do that. Now, I got to take some issue with this from an access standpoint, from a transparency standpoint, because number one, everybody that was in court already heard what these statements were that are going to be subject to suppression. So they are already reporting those statements far and wide. Okay, the publicity is out the door. And so what kind of incremental prejudice there might be from seeing these words come out of Luigi's mouth instead of being in, you know, black and white typeface in print attributed to him, very difficult for me to understand why that is somehow going to prejudice his right to a fair trial when the statements are already out there being reported by virtue of the fact that we have public courtrooms that the press has a right to attend and report on. So I don't see the justification here at all. I really don't. But more to the point with this process and this booting out of the reporter, like there is a pile of case law like this high about how to protect the First Amendment rights of the public before you are able to close off part of a court proceeding. The public has a right to be heard on that. And it was quite crystal clear to me that this lady was attempting to be heard to oppose the sealing because the state's not opposing it. Nobody's spoken against it. So she's trying to be heard. She has a right to be heard. And this, Gestapo looking process unfolds to rush her, bum rush her out of the courtroom. I mean, it was wild. Did not like that at all, one bit, from a transparency standpoint. Not just, you got the hearing wrong, but also you won't even be bothered to hear from the public about what their interests are and what their position is on whether people should be able to see this body cam footage for themselves with their own eyes. And, part of the reason why that is a problem as well, we're like back in Delphi country here, right? Because we don't have cameras in this courtroom. We're not getting an audio feed from this courtroom. If you're not sleeping out there in the cold on the street of New York or have your press pass, you're not going to get in to see what's happening. And so it's created this privileged class of people who get to see it. And all the rest of the peons, have to wait until the court decides it's a good time and now you're allowed. I mean, I talk about the imperial court, and this is exactly why, when I decide you can see it, then you'll be able to see it. Otherwise, you shall sleep out on the sidewalk in your sleeping bag if you want to know what's happening in the court, and if you want to be able to have your own opinion about what happened and the process that's unfolding and the justification for it and so forth. I have such a problem with that. This was a huge blow from a transparency standpoint, in my perspective. This case really doesn't need that. Like, of all things that the case doesn't need, a big cloud over transparency is not one. Like, I can live with not having a camera in the courtroom. I don't like it. I don't like it at all. I think there should be a camera in every single courtroom, to quote the fabulous Emily D. Baker. Yeah, there needs to be cameras in every courtroom, because we have now seen over and over and over again how tempting it is for the media to report a narrative that is distorted and often not true. But even in the best case scenario, me, the lawyer, trying to watch what's happening, the media has no idea what matters. They don't know what's relevant to the legal issues. And so you get these reports of, yeah, they spent several hours asking questions this morning. Yeah, no shit, Sherlock. It's a freaking evidentiary hearing. That's what happens. That could not be less insightful or informative. And so, but yet these are the folks who are prioritized, right, to get into the courtroom and be able to share with the rest of us what's happening. So I don't like there being no cameras, but I can live with it. I can live with it. If it's temporary, there will at some point be transcripts. Don't love it, but I can live with it. But now you start sealing stuff off that we're supposed to have a right of access to. There's no First Amendment right to cameras in the courtroom, but there is very much a First Amendment right to view court files and exhibits, particularly exhibits in a criminal proceeding, exhibits that relate to the basis for the adjudication, the decision that's being made. We have a right to evaluate the quality of what is happening in the courts. Are they making good decisions? Are they bullshitting us? Are they going to do this thing like this cop did of telling us the facts are something other than what we can see with our own eyes? We have a right to know that. And that's why we have a right to access these things. So the disrespect that this is showing to the people that are interested in this case and want to know, that's not a good look. And it's really, really not what this case needs. So that was quite disappointing to see how that all went down at the end of the day. So guys, That was all my 27 pages. That's what happened on Tuesday. I have no idea how they are going to get this done. As I already said, in the time period that they've allotted, it's supposed to be done on Thursday, but they've gotten through what, like 6, 7 witnesses. There's supposed to be 20 some. This is just not going to happen. And so I don't know what that's going to mean from a just practical standpoint. Are they going to be able to continue this hearing next week? Just keep court going? Are they going to have to like call time and come back? Like normally a judge's schedule is pretty well booked up. If you want a multi-day hearing, you know, you need some notice to be able to get that arranged. So I don't know if it's you know, if he's already booked up next week. They might have to look down the road for when he's got, you know, another several days available. I don't know if the judge is just going to be like, look, the time you got is the time you got. That would be kind of problematic and troubling to me from the standpoint of, you know, just basic due process. You have a right to put on the evidence you need to be able to make your case, make your arguments. And we haven't even gotten to, you know, the defense having an opportunity to put on evidence yet. We're still just in the state side of things. So yeah, I haven't seen if maybe there's news about that or anything as far as an update, but I am not real confident at this point that things are going to get done in the time frame that they expected. How are things going motion wise, you know, motion to suppress wise? What should we be expecting? Here's some of what I can say, because of course, you know, they're not done. There's a lot still to go. Judges, just by nature, are always going to be hesitant to grant a motion to suppress. Okay, their inclination is always going to be to let it in. Very rare exceptions to that. And again, this just goes to the kind of political nature of the position. Whether judges are elected or appointed, whatever the system is, there's a club. You best believe there's a club. And you have friends within that club. You know who your allies are, who your allies aren't. And people rarely make it into a judge's seat for being soft on crime. And we're in kind of a vindictive era in terms of criminal justice. You know, we see a lot of pendulum swings in sort of what the attitudes are about the criminal system. And we're at a point right now where, you know, there's a lot of outrage, a lot of like, you know, judges should be punished for letting people out on bail and stuff like that. You know, talked about some of that on my Substack. So for the judge to be making a decision that would potentially make this entire case go away, it would potentially make this entire case go away. If they said he was required to be read his Miranda rights before they asked him that question, so why'd you lie? They didn't necessarily have cause to arrest him on any of the charges at that point because they didn't know it was a fake ID. It wasn't until he answered that question that he told them, oh, it was a fake ID. They didn't necessarily have that. So if they didn't have that, they could not have arrested him. If they could not have arrested him, they could not have searched him incident to arrest. If they had not arrested him, they can't take him down to jail and do an inventory search of his belongings. You got a lot of fruit of the poisonous tree that flows downhill from that. But even if you allow the statement, you know, even if the statement is okay, we still got to go through this search and the justifications for it and what law applies and so on and so forth. And, you know, hey, if New York law applies here and this is not in a grabbable distance, or there was not an exigent circumstance where they had 10 cops there, 3 of them around him, he's in handcuffs, you don't get to these searches. Once again, you don't get anything that is downstream from that. And while I don't believe we've seen any of the New York search warrants or the arrest warrants or anything like that they used to get their evidence, it is almost certain that they relied on the evidence that was obtained from these searches because, as Detwiler admitted, what they had at the time was not enough to arrest him for being the New York shooter. They had to get into his backpack and find everything in his backpack to get to that point. So if they hadn't gotten into his backpack, they don't get to that point. And that means, you know, you're in a position where the case is potentially going away. The judge doesn't want to be that judge. He doesn't want to be that judge. The one who's responsible for letting a shooter get away, he doesn't want to be that judge. So it's defense is always on the back foot with these types of motions, even though it's ostensibly the state's burden of proof and the presumption is a search is you know, warrantless search is unreasonable and so on and so forth. The defense is always on the back foot with these motions. So you know, the facts have come out in a way that there's definitely some stuff in there that is favorable to them. But there's also a lot that has the ability to be couched in terms of credibility and just who the officer believes and what he believes. You know, does he have a problem with the body cam being turned off? Does he have a problem with, you know, them waiting 10, 12 minutes to move the backpack that they're ostensibly so worried about? He can find reasons to say, you know, all he has to do is say, I think this officer was credible. It's really all he has to say. And then he can accept as gospel truth anything that this police officer had to say. So I think the stuff that came out that is most helpful to Luigi through this hearing so far is the cooperation, the communication that was going on between the Altoona Police Department and the NYPD as they are conducting this arrest, because that starts to make it look like, well, Altoona PD, now you're not just acting independently as your own law enforcement investigation. You are acting as an agent, as an arm of the NYPD in their shooting investigation. And if you're doing that, then the standards that would apply to NYPD for doing an arrest and a search and questioning and so forth, those are the standards that should apply to you. So I think that has put them in a much, much stronger position on this whole choice of law issue. What law applies here? To say it's New York law that needs to apply here, not Pennsylvania, because they weren't acting independently, just as Pennsylvania in furtherance of Pennsylvania interests. New York has a substantial interest in not allowing its police officers to evade the obligations by just enlisting the help of some sister state law enforcement agency. So I think that is extremely helpful, because that really weighs the scale in favor of applying New York law, and New York law is much, much more favorable on this search issue than the Pennsylvania law is. So then, you know, the exigent circumstances and so forth, we get to see that with our own eyes. At least we in the courtroom did, and someday everybody else might be able to as well. But you get to see, like, how he behaved, how they interacted with the backpack, how they immediately, you know, separated him from it so that it wouldn't pose a risk. But then somehow it's like a risk once they have him in handcuffs. That one's going to be tough. And then how we see with our own eyes how they've taken him out of the McDonald's in handcuffs, but they're still over there searching the backpack. That's going to be hard to justify as an exigent circumstance. I think that's going to be really difficult. So there's definitely stuff that's come out that leans in favor of, they got some good arguments here about why this motion should potentially be granted. But you're always on the back foot as the defense, and they are going to, I mean, I don't like to be too cynical, but it's just I've been been in the system a little too long not to know better, They're going to bend over backwards to try to justify it any way they can, because the judge doesn't want to be the judge who threw out the case, and that's ultimately what what the consequence of granting the motion is likely to be. So that's where we're at with the case. That's where we're at with the case right now. I'm going to probably head down and see what things are looking like down by the courthouse right now. I don't have high hopes, like I said, for trying to get in for Thursday. If anybody's got, like, what's your favorite live tweeter or whatever, feel free to pass it along. My favorite so far has been the Inner City Press. He does a lot of courtroom coverage, and so seems to be kind of the most in tune with, like, what actually matters in a court case. Lauren Conlin too, who I met in person. I know her from Twitter, but met her in person. She does a good job. She does enough court reporting to kind of have that same perspective. Haven't really seen a lot of other, like, really great ones. So if any of y'all know some, definitely feel free to throw them in the comments or in the chat or anything like that, and I'll check them out, because that might end up being my way of following what happens with the rest of this hearing as well. But I am glad I got the opportunity to kind of come down and just take in the scene for myself, see how things are going on. Particularly appreciate being a witness to this whole battle on transparency that now seems to be happening, since as many of you know, that is a very important issue to me. Courts belong to the people. The legitimacy of the courts depends on our ability to monitor what is being done in our names and what we are being told is justice. So if we aren't able to do that, well, now we are just being tyrannized by yet another branch of our government. So with that, guys, I appreciate you being here. I don't think we have one comment here from I Love Pussycats. Mom, I love you and I miss you. Thanks for boots on the ground. Well, I'm very happy to be here. I would love it to be not so complicated, but that's one of the reasons why it is so important to try to make the effort when they're going to make it this difficult to be able to see, to make sure that we got some sources of detailed information in the courtroom. So appreciate your comment. With that, guys, appreciate you all joining me. It is actually a sunny day in New York. Not that you ever really get to experience that in New York, because you walk down the street and the buildings like block all the shade, but at least you can go to a park from time to time, or like just look up, and seeing blue sky is kind of refreshing. But that does mean it is probably pretty bitter cold out there. So yep, still a real coin toss on sleeping out another night on the street. I don't know, we'll see, but I'm gonna go check it out. Guys, thank you all for joining me. I really do appreciate it. I appreciate your interest in this case. I appreciate your interest in the justice system and how it's working, and making sure that it remains accountable to we the people. It's what it's really supposed to be about. Public safety is supposed to be about us and our protection. Then surely we have an interest in watching how it unfolds, and monitoring how it's being done, and making sure everybody is playing by the rules. Because if the police don't have to play by the rules, then why would anybody else think they have to? The whole thing falls apart if you have special exemptions for certain classes of people, some animals more equal than others. So with that, guys, I am out of here. Thank you again, and I will see you all again soon.